May I please, Your Lordship? Lordship, I beg to mention 29, item 29, 32, and 33 of the daily for adjournment. We have already submitted our adjournment petition.
Why do you want adjournment, sir? Why do you want adjournment?
What is the reason? Leading counsel have submitted her leave application. Lordship.
Okay.
And moreover, due to
In all
some
three
personal
cases.
inconvenience.
Okay, very well. A request is made to adjourn the matter on the ground that the arguing counsel is not available today. The other side has no objection. You are from the petitioner side.
Yes, Lordship, I am appearing on behalf of
The
MS
petitioner.
Divo.
Proxy counsel लिख दीजिएगा इनका attendance. And the other side has no objection. Has prayed list after 4 weeks.
Deeply obliged.
May it please your lordship. I beg to mention item number 27, lordship, with the
27.
consent of the other side. We are filing our additional affidavit today, lordship. So kindly adjourn the matter.
You are appearing for
I am for the respondent number 5 to 10, lordship.
respondent number 5 and counsel appearing for the respondent number 5 with the group numbers 5 to 10. Please for time to file an additional affidavit.
Yes, lordship.
The other side, you
Please, your lordship.
don't have any objection?
No, I am not the other side, your lordship.
Okay. The other side has no objection. List after how much time do you need?
Your lordship, 2 weeks.
2 weeks as prayed.
Obliged. May I please your lordship? Your lordship, I beg to mention item number 18 of the daily lead, your lordship.
Yes, please.
Your lordship, the petitioner has directed us to withdraw the matter. So that
And counsel MS, what's your good name, ma'am?
and Deka.
And Deka, appearing for the petitioner, submits that she has been instructed by the petitioner to withdraw the contempt case, a contempt petition. Accordingly, the instant contempt petition is disposed of as withdrawn, rule is discharged.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 7, Your Lordship, of the
Yes,
daily list.
please.
Lordship, we are being led by Dr. Ashok Saraf, senior advocate in this case, Lordship.
Mhm.
Lordship, due to some unavoidable circumstance, Lordship, he had to, he's out of station, Lordship. And,
Item number
since-
7 is with a bunch of matters.
three cases. Yes, sir.
6, 7, 8, brother.
6, 7, and 8.
They are all
The
connected.
6 and 6, 7, 8, the 6 and 8 I am appearing. Since the lead counsel, he wants to lead the case.
Mhm.
Since I so let it be adjourned all the 3 cases.
All right, a request is made to adjourn the matters on the ground that the arguing counsel, senior counsel is not available today. List up 2 weeks as prayed. So, Mr. Priyal,
Yeah, he's appearing for the, no, it is for the respondent.
Next week.
okay.
Next week.
You have obtained consent from the.
The other side, you have asked the other side?
Yes, sir, Lordship, the consent of the other side.
Very well.
Highly obliged.
Your Lordship, I beg to mention item 36.
Yes, please.
Your Lordship, I pray for adjournment as senior counsel for the petitioner. His aunt has expired. Your Lordship, he had to travel to Punjab.
Then it is stated that counsel for the appellant has had a bereavement in the family, has prayed list after 3 weeks.
Oblige you.
May I please, Lordship? My lord, I may be permitted to move urgent writ petition, Lord.
What about, sir?
It is relating to the SARFAESI matter, Lordship. Auction is fixed today. E-auction.
So
I have
have
already
you not
filed-
closed the DRT?
Lordship. No, I'm not going to challenge. Only my simple prayer that I have negotiated with the buyer. I'll sell my flat for 1 crore 20
For
lakhs.
that purpose, you can go to the DRT and make the same request, sir.
Today is fixed, Lordship, for e-auction.
So they,
I
The
only.
date must have been
accommodate
fixed
simply
after
time. I
you intimation,
have
sir.
arranged the Lordship Mary. Only payable amount is 56 lakhs.
Very well.
And I am going to solve.
You can ask your co-counsels. We have not been entertaining these writ petitions.
Already
the-
it has been
the
filed, Lordship. If your
Result
Lordship,
is fait accompli.
your Lordship will find there is no.
Very well.
Lordship may
Get it
reject
listed tomorrow, sir.
my- Lordship, auction is fixed today.
Then why do you wake up at the last hour? What is the reason? What prevented you from approaching the court earlier?
Not, it at 2 p.m. Lordship, if the time will permit.
I'm doing it. We don't.
the other side, maybe.
What about the other side? Who's for the bank?
Bank is Standing Council of Eco Bank.
So have you served copies on
Yes,
the,
copy I have, sir. Already it has been filed, serial number have been given.
have you informed him that matter you are going to make a mention today?
No, I will inform the staff. Serial number has been given 2365. Because copy has been served.
Availability of the other company.
Let it be listed. Yes, we are granting you permission to get the matter listed, sir.
Obliged.
Yeah, please, your lordship. Lordship, I beg to mention item number 28.
Yes, please.
Lordship, the engaged counsel is currently out of station. With the consent of the other side. I'm praying
Counsel
for
put the
adjournment.
appellant, place for time. The other side has no objection. List up 4 weeks.
Item number 1 of daily list for motion.
Meet please, your lordship.
Yes. No, no, no.
Your lordship, the facts are that on 11/2/2004, the army personnel came to the village of the petitioners and picked up the husband of the petitioners.
Well, on last occasion, Lordship has directed, I'm appealing for response number 4, 5, and 6.
Yes.
Lordship has directed to bring the case diary of
Yes, sir.
Bokajan PS case. Well, the SP has communicated, well, he has paid for some more time. Lordship give us 2 weeks time.
Why this writ petition coming up after 19 years of the incident? Can we find out?
Your lordship, they are villagers, innocent villagers.
So does that give them an extra leverage to get the limitation condoned?
No, your lordship, but still, your lordship, my right to
Sir, please let us know
my right to life
if
has
you are
been.
knowledge on the aspect
Okay.
that the ignorance is bliss if the person is a villager.
But your lordship, my
19
fundamental
years.
right has been violated. That is a fact.
Oh, that is true. So we can exercise writ jurisdiction even after 20 years. Is that the law of the land? Satisfy us first on that.
Your lordship, on the next occasion, sir.
Well, this is the communication I received from the SP Karbi Anglong.
Because for all we know, Mr. Counsel,
Hello.
the procedure regarding destruction of case diaries beyond 3 years, no record is preserved. So there is no question of the case diary being available now.
But they have in fact went to the court. They are trying.
Even the court, the records are not
No, no.
retained for such long a period.
True.
What have you mentioned regarding delay? Please point out.
Regarding delay, I have mentioned in para 16, your lordship.
Para 16, read please.
Para 12.
Yes.
That the petitioners beg to state that the alleged incident took place on 11/2/2004 at Thonpahai under Bokajan police station by Garhwal army. Though on behalf of the petitioners made representation before the district authority on 2/6/2004, but no inquiry was conducted. Thereafter, the application was filed before the chairman of Human Rights Commission on 9/7/2004.
So what has
The same-
happened to the proceedings in the Human Rights Commission, please?
Human Rights Commission disposed it of, saying that it was due to military operation and there was firing exchange, due to which.
So
three
now there is
bodies were-
already a finding of the competent forum on this very factual aspect. How do you expect the writ court to appreciate these facts and give a different finding, please?
Then your lordship, a direction may be given to the Human Rights Commission to dispose of our review, which we have filed in the year 17/12.
Is it subject to judicial review on of this court? The proceedings of the Human Rights Commission at Delhi? File a SLP, sir.
Your lordship, one opportunity may be granted, my senior may be heard on the next occasion.
You already argued for 10 good minutes, sir.
Your lordship, last one opportunity.
You're right, SLP. There is a provision, there is a notification which.
But now he's asking for a wholesale inquiry. How is it a habeas corpus, sir? First of all, let us know.
Your Lordship, the dead body that we did not receive it. That after 2 to 3 days, when some of the people, some of the villagers went to the police station, they came to know that these people were lying there.
So the body was received, postmortem was conducted.
Postmortem was conducted, but the body was
Now,
not
how-
received
how
by the
is it
family.
Matter to be entertained by the division bench, please. Some
Your Lordship,
tough questions
next,
to answer.
next time, Your Lordship.
Tomorrow,
Tomorrow.
okay.
Obliged.
Item number 2,
May legal Really. The reason for which this PL is filed is at page 30.
3-0. Yes, please.
My lord, here the 12 villages of Kachar district has been, my lord, transferred for administrative reason to the administrative district of Karimganj.
Hmm.
I have stated in my paragraph from 8 onwards, the inconvenience that is caused to us. Next page, your lordship will find page 31.
You know, sir, in every new kind of development
My lord,
where the dynamics are changed,
my lord,
people are bound to face inconvenience for a while.
my lord, my lord.
But
I
then these
understand.
things, with the efflux of time, everybody gets the advantages of decentralization.
My lord, last but one paragraph of page 31. Once a draft proposal of delimitation of constituency in the state of Assam is finalized by the commission, it shall publish in the central and state gazette for inviting suggestion and objections from the general public. In this regard, a notice will be issued to such and such. I have made my grievances in my representation, taking into consideration that.
You
the-
submitted representation.
Yes, my lord.
Where is the
My
representation?
lord, it's-
So we
Page
will ask the
33.
competent authority
Yes, but
to
page
consider
33.
objectively consider your representation.
My lord, that.
लिखा दीजिए।
Page 33.
लिखा दीजिए।
Page
Next slide.
33.
Sorry?
33.
33.
That is still pending.
Pending, my lord. My instruction goes.
So we dispose it off, Mr. Advocate General.
So far as this representation is concerned in terms of page 31, that is before the delimitation commission.
Hmm.
That exercise has just started. So, and what the representation he has submitted, it is before the state authorities.
They don't have
Both
any.
are totally different areas.
Yes, true.
So my lord, to the appropriate authority will file a
You
representation.
file the
And
presentation.
that
to
is
the
regarding
appropriate
constituencies, the page 31. And this is regarding the district composition.
You can always approach.
My lord, we have filed against the notification. Your lordship will find prayer for reconciliation of notification dated
Once it-
31st December.
Eve of the notification, eve of the process is
The timing. Let it file the representative to the concerned authorities.
My lord.
We will permit you to file representation to all concerned authorities. Let them consider the representation objectively.
My lord, my lord.
Mr. Reji,
I have no objection. The only difficulty is that there is a notification of the election commission because election commission is doing the delimitation exercise in Assam. That no changes of boundaries of any of the administrative blocks or districts can be done during this process. So that is the only difficulty. I'm just
Let
apprising.
them
Yes, let him
objectively
file, Lord.
consider it.
We'll
Let
take
them
a call on that.
In this democratic process,
Yes, Lord.
everyone has a right to
Absolutely,
raise his
Lord.
voice.
Yes,
So let it be considered.
yes. And this is a dynamic situation.
heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the petitioner, and Mr. D. Soikia, learned advocate general appearing for the state, assisted by Ms. R. Borwa. Whereas this PIL is preferred by the petitioners who are residents of the district of Kachar, Assam. They're aggrieved by the fact that on the eve of the notification issued by the Chief Election Commissioner,
Page 30, my lord. Page 30, Principal Secretary, Government of Assam.
Page 30 is by the state of.
on the eve of the process of commencement of the delimitation exercises in the state, which is to have commenced with effect from 1st of January 2023, the impugned notification dated 31st of December 2022 was issued by the Principal Secretary to the Government of Assam General Administration Department. By this communication, the revenue villages named in the said notification have been the existing administrative district in respect of the revenue villages named in the said notification has been changed from Kachar to Karimganj. According to the petitioner, such sudden change has resulted in inconveniences to the denizens of these districts, besides causing administrative hardship. Representations were filed before the
Chief Secretary.
Chief Secretary, Government of Assam, as well as the Principal Secretary, Government of Assam General Administration Department, which, however, according to the petitioner, has not been considered. Full stop. Where Mr. Devajit Saikia, Learned Advocate General, appearing for the state, submits that as on date, the delimitation process has commenced. It has started,
Yes.
and accordingly, the appropriate authority would be the Delimitation Commission set up by the Government of India.
No, that is not my submission, Lordship. I said that, Lordship, the delimitation exercise has been done. And according to him, he has filed this representation of 18 January. In terms of the notification, in terms of the election commission's notification or document which they have annexed to page
Page
31.
30.
No, your submission is that it is the Delimitation Commission who will decide.
They are not the competent authority to change the districts.
No. The delimitation process has started.
Yes, Lordship.
It is to be under the directions of the Election Commission. It is to be headed by the Commission.
No, that is their purpose is to redraw the constituencies.
Exactly.
But what he is trying to project before this honorable court is a change of the boundaries of the district.
So therefore, that is kindly hear the order.
What is the argument is that once the ECI has started the process of delimitation,
That's what I was.
the administrative boundaries cannot be changed.
We cannot do anything now.
That is what.
That's right. That is what I was.
So, yeah, precisely.
The submission of the learned AG is that once the delimitation process is started, there is no question of any change of the boundaries of the revenue districts unless the process is completed. Full stop. However, he is fairly submitted that the petitioners may approach the authorities concerned, including the Delimitation Commission, for redressal of any of their grievances. Full stop. Mr. Roy Chaudhary, Learned Counsel for the petitioner, submits that given the liberty, he would like to approach the authorities and file appropriate representations seeking redressal of their grievances. But in view of the submissions at the bar, this PIL is closed, giving liberty to the petitioners to approach the competent authority seeking redressal of their grievances. Full stop. They will also be entitled to approach the Delimitation Commission seeking ventilating their grievances, as well as the state authorities. The authorities concerned will thereafter consider and pass appropriate orders in their representations for file. PIL is accordingly disposed of.
Can I pray for a time period? Can I pray for a time period that after we file an application?
Reasonable period.
Item number 3 for admission.
Yeah. May it please the last. My lord, the matter relates to provincialization of the services of the appellant. My lord, the writ petition was filed, or rather it was structured on the basis on a wrong premise, my lord. Actually, what had happened, my lord? The petitioner, the appellant was originally appointed on, my lord, 2/8/2006. And going by her initial date of appointment, she was the sixth teacher. But what happened, my lord, on 4/7/2011, the then headmaster of the school died, my lord. Thereafter, my lord, the petitioner status was upgraded from sixth to fifth teacher. Now, my lord, the projection was made in the writ petition as if when the headmaster died, authorities should have advertised the post, then the petitioner could have applied and all. Actually, there was no scope of making any advertisement because petitioner was already employed. So, my lord, taking that date, the learned single judge has interfered with the provincialization of the service of the appellant. My lord. That is the case in nutshell. And my lord, the writ petitioner, in my humble submission, they had no locus standi. They were not teachers of the school. Their grievance was that if the post is advertised, in that case, they will get an opportunity to apply. But that is not
this
the.
argument dealt with, kindly read in the impute
Yes,
judgment
yes, my lord.
that the petitioner was already employed.
Yes. My lord will kindly come to my lord, page 114.
But when we start, see the beginning of the judgment, it
Yes.
says
Huh.
her appointment was cancelled. The petitioner's appointment was cancelled. Please
No.
read the beginning of the judgment.
Yes, my lord.
Para one.
Para one.
Yes.
The petitioner challenged the condemnation her appointment was earlier cancelled. Yes, they say, my lord. Now I'll come to that aspect, but there is no scope of at the venture stage, my lord, the interference of the education department is not called for. Then I'll come to that, my lord. If your lordship will kindly come to para 14, page 114.
Yes, please.
The facts and materials on record prima facie show that on 21/6/11, when the first list was prepared for the purpose of financial assistance, respondent number 7, that is the appellant, was not in service. Because on the day, the headmaster was alive. The said respondent, while dealing with the aforesaid averment in para 4 of her affidavit in opposition, has simply stated that the aforesaid facts are matters of record.
So this is virtually not disputed
Yes.
that you were not in service.
No, my lord, the issue is this projection was not made, my lord, because the projection was on 4/7/2011 when the headmaster died, then I was appointed. The fact that I was appointed on 2/8/16, my lord, this was not even gone into. I guess
16.
6. My lord will kindly, I'll just show
the
that.
petition, sir.
Yes,
You were there in the petition.
yes.
Were you not supposed to bring this fact on record?
No, I'm only saying, we have filed our affidavits are there, my lord.
Very well, let us continue.
My
Let us
lord will
continue.
kindly come to page number 30, my lord. Let me give the facts.
Just hold on. Please continue with this paragraph.
Reading, my lord, I'm sorry.
Because the learned single judge says respondent number 7 was inducted in the school with effect from 2/8/2001.
11.
11 rather, sorry.
Yes.
So then how that date 2006 comes in?
My lord, because I was appointed. And let me read it further, my lord. The
Yes,
said resolution, the said respondent number 7 was inducted in the school with effect from 2/8/2011, and the connected resolution number 1 dated 15/7 was approved by the district elementary education officer. Said arrangement being cancelled by order dated 17/11/2011 by the district elementary education officer. The consequential order of provincialization of the school dated 14/5/2013 did not contain the name of respondent number 7. And in fact, against serial number 3, remark was vacant. That being so, it is failed to understood as to how the name of respondent number 7 could be inducted,
Yes.
could be inducted in the dice list of for the year 2011-2012, that too by inserting her name by hand. It is seen from the dice list annexed at page 22 of the writ petition that apart from inserting the name of respondent number 7 by hand, there were overwriting which gives rise to give suspicion in the action of the respondent authorities. No explanation has come as to why her name had to be inserted by hand and why overwritings were there in certain figures which did not even contain any endorsement and signature. In the said list at page 28, 2 more names appear after the name of respondent number 7, whose date of joining are however prior to that of respondent number 7, namely 2004 and 5 respectively. Regarding the aforesaid anomalies, Mr. Sharma, learned counsel, submitted that school was in venture stage and the authority was not well acquainted with the procedure and maintenance of records. And since both the office bearer of the schools were uneducated, inadvertent mistake may have occurred. The perusal of the records in original which have been produced by the learned counsel appearing on behalf of the headmaster, more specifically the teacher attendance register shows glaring anomalies. From August 2006, when this is where respondent number 7 is projected to have been utilized as an assistant teacher by the respondents, her name has been separately written by bisecting a particular column between 2 teachers. That apart, there are overwritings in her name as well as a use of whitener. R. Sharma, learned counsel for the headmaster, tried to justify that the same had to be done due to want of space, as last column was of non-teaching staff. However, it is seen that register itself is a teacher register and not for non-teaching staff, and therefore the aforesaid explanation does not appear to be convincing at all. Though it is a settled position that a writ court would not embark itself to make a roving inquiry into disputed questions of fact, but if anomalies which are glaring in nature are brought to the notice of this court, it cannot remain a silent spectator, more so when it is connected to the public employment. Technical objection of not praying for an appropriate writ would perhaps not come in the way of granting appropriate relief, which a party has been able to make out. In this connection, one may gainfully refer to Budwarkana. In view of the aforesaid discussion and consideration of the materials on record, this petition is allowed by holding continuance of service by respondent number 7 as an assistant teacher of Akabasti ME school in the district of Sonitpur is illegal and hence could not be allowed. Further, this court directs respondent authorities, more specifically Director Elementary Education, to examine whether withdrawal of 1.52 lakhs by respondent number 7 was in accordance with law, if not to initiate recovery proceeding. In making such inquiry, the Deputy Commissioner of the district would render necessary cooperation. The resultant vacancy on discontinuance of the service of respondent number 7 may be filled up by duly conducted recruitment process and giving petitioner an opportunity of to participate if found to be eligible and qualified. Now, my lord will kindly come to page number 23, my lord. This is the English standard translation of the, my lord, vernacular, which starts at page 26. If your lordship would kindly come to page 24. When the school was venture stage, my lord, resolution number 1. Considering the increase in the number of students and difficulty in discharging classes, today's executive meeting decided to appoint Ms. Mumta Begum of village Akabasti on merit basis as an assistant teacher of Akabasti ME school. Then my lord will kindly come to page number 30.
So how do you explain page 43?
My lord.
Entry number 21.
Yes. Yes, my lord. Yes. It was shown as vacant.
Yes.
Yes. Now explanation is there, my lord.
Yes.
If your lordship would kindly come to page 45.
Yes.
The same DEO, my lord.
This letter does
List
not-
of recommended school for provincialization with non-recommendation incumbents. Kindly see, my lord, serial number 5.
This letter does not bear any signature, any endorsement, any serial number, nothing at all.
Which one, my lord?
Simply this one, 45 you are reading.
Yes.
Who has endorsed it, sir?
From the online.
No, this we got online from the, my lord, website of the department, my lord.
46.
My lord, the page 46 is there. Kindly see, my lord. Page 46, this is a letter by the district Mumtaz Begum, my lord. Now, there was a written letter. As per the proceeding book, it reveals that the applicant was appointed as assistant teacher by resolution number 1 of the executive committee meeting dated 25/7/06. And it further reveals from the proceedings of the executive committee that she was upgraded to 5th teacher by resolution number 3 of the executive committee meeting dated 8/7/12/2011. Attendance and register were also verified.
Projection is that she was appointed in 2006.
Yes,
If at
and
all, even if we were to give any credence to this list at page 45,
yes,
in this your date of joining is shown as 8/2/2007. So
Two-
your existence in the school
Ah.
before that is otherwise also highly doubtful.
no, my lord. Lordship will kindly come to page 48. I'm placing the documents, my lord.
Yes,
Lordship will take an appropriate view in the matter, my lord. We'll leave it to that.
yes.
This is written by the DEO, my lord. Correction of name, title, dates of joining of teachers of taken over. With reference to the subject cited above, I have the honor to submit herewith a statement of few middle English schools showing incorrect names, title, date of joining, etc. In this connection, it is to be stated that some names, title, dates of joining has been incorrectly depicted in Annexure A of the Middle East, so that's the page 45. I therefore request you for necessary action. Now, my lord will kindly come to page number 52. Page 52, my lord.
Yes, please.
My lord will kindly come to column number 11. This same vacant aspect was shown. Now, my lord will kindly come to 16, column number 16, remark. Actually, the date of joining of Mumtaz Begum is 2/8/2006 as per records of the school.
That is why the learned single judge was perfectly justified in directing an inquiry. This is fabrication on the face of the record.
No, my lord, if the inquiry reveals anything of this sort, certainly the appellant should be taken to task. But without inquiry, my lord, how the learned single judge formed the opinion, my lord? There was no,
These
in
two
fact, a roving
documents are-
inquiry was made, my lord. Now kindly see, my lord, who is the petitioner?
The petitioner may be a public spirited citizen for all we know. This is fabrication on the face of the
No,
record.
my lord, end of the matter, the DEO, who is the concerned officer,
We can give you the chance to participate in the inquiry. If you succeed, you may get the benefits, but otherwise the direction is absolutely. open.
no, my lord, my humble submission is, first there has to be an inquiry, first the report, then lordship will take a call.
Prima facie case.
No, my lord.
Prima facie, there is a
No, my
fabrication.
lord, it will be
If
like,
at all,
it will be like putting the cart before the horse.
Maybe
If the High Court forms
the
the opinion
corresponding
without an
record-
inquiry,
the law evidence, appreciation of evidence says document first in point of time is to be given
due
Credence.
credence. No,
due credence.
No, my
So
lord.
the first document which, when we find the list which was sent for financial assistance,
Yes.
the post is shown vacant.
No, my
There
lord.
was no reason.
No, my lord. My name did not appear because the headmaster was there.
So the post is said to be vacant. Please
No, my lord.
read it again.
No, I have seen it, my lord.
Then there was a rectification at your instance. So there the suspicion is confirmed regarding everything being
No, my lord.
collusive.
If an inquiry reveals that I was not appointed in 2006, that's the end of the matter for the appellant. But where is the inquiry, my lord?
Inquiry will be made now.
So therefore, my humble submission is, my lord, let an inquiry be made and lordship will keep this proceeding pending. Let there be an inquiry. And my lord, by virtue of the interim order, I am working, my lord. So my humble submission is, my lord, lordship will take a call on the learned single judge's order. Let the director place the inquiry report before this honorable court.
Yes, please. What has happened to the inquiry?
My lord, the inquiry has not been held because the order of the learned single judge was stayed, my lord.
The entire order has been stayed.
Yes, my lord. The order is stayed, my lord. She is working and drawing salary also as per my instruction, my lord.
Stays passed by order dated
My lord, order is perhaps, my lord, 11-19.
Modify the order.
So,
So we'll modify the orders. We'll say that let the inquiry go on.
Yes.
And you place the inquiry report for the court's perusal in a sealed envelope.
Yes.
I should also be allowed to participate in obviously.
All.
No, I think the inquiry as such may be conducted by the district scrutiny committee. Section 10, I believe, they have also averred in the writ appeal.
Yes, there is a committee, my lord.
There is a committee, and if there is no.
Must
committee,
be under the
deputy
district
commissioner-
education department,
Yes.
It is headed by the deputy commissioner
deputy commissioner.
or his nominee.
In fact, my lord, this statute itself envisages that committee. In fact, my lord,
Director,
any
elementary
grievance
education
regarding
was
provincialization
the
should
inquiry.
go to the committee. They instead come here.
Learned single judge directed the director elementary education.
That was post setting aside the appointment of the.
That is for recovery.
Recovery.
From the education department officials.
Director of it examine whether.
So the inquiry is to be
regarding
done by
that-
the deputy commissioner.
Yes. In fact, if a lordship would kindly have the act, my lord, that committee is already there.
Is pass on the act.
Section 14, second. 14. Section 10, na? Section 14, my lord. Page number 123 of the book.
Appellate authority,
Page 123.
state
Yes,
level scrutiny committee.
against the recommended district
No, that
committee
is
and
an
state
that is
government.
an
in-
appeal.
Ah.
That is an appeal. Where is the power procedure to be adopted by? the
Procedure
scrutiny
is
committee?
section 19(2), my lord. To adjudicate the disputes for redressal of grievances relating to teaching staff of non-government educational institution, as well as disputes concerning disciplinary action, genuineness of establishment of school and claim for
So
provincialization.
let there be an inquiry under section 19(2),
Yes,
and then we'll get the result.
Time period
Yes.
if can be.
Time
19
period, yes, we'll prescribe.
yes,
19.2 is before the tribunal.
my lord.
19.2 is tribunal.
Yes,
Yes.
it has been constituted by the state government, my lord.
But it is before a tribunal, not before the scrutiny committee. We
Yes,
are asking, where is this provision for the scrutiny committee?
that is section 14, my lord.
14 is appellate authority, sir. That refers to a scrutiny committee.
Page section 13, my lord, for district level.
District.
Section 13, subsection 1.
Yes. The brother at the
Hello.
time when the provincial
Right.
but subsequently, it has been done. Whether any inquiry is permissible by this committee. Scrutiny would be permissible before the process is undertaken. But.
My lord, issue is like this, if anybody has any grievance regarding provincialization, ideally the matter should go before the appropriate committee,
Yes.
maybe district committee.
So let it be, let the inquiry be under section 13, 10 and 11,
Yes,
and then we'll get the report.
yes,
After hearing the learned counsel for the parties and producing the material available on record, comma, the addendum stay order dated so and so is modified, and it is hereby directed that inquiry into the allegations pertaining to irregularities of the illegalities in the provincialization of the appellant shall be conducted by the scrutiny committee constituted under section 1310 of so and so,
I didn't want.
1310 and 1311. The inquiry after hearing all concerned parties shall be concluded within a period of 2 months from today, and the report thereof is submitted for the court's perusal in a sealed envelope by the next date of hearing. However, the direction to continue the however, the appellant shall not be discontinued from service.
Deep level.
The opportunity to the.
All parties
Deep level.
re-notify on 8th May. 8th May.
Item number 4 and 5.
Sorry. Council,
Yes.
tribunal matter.
May please, your lordship. Lordship, this petition is directed against an order passed by the learned CAT. Lordship will find that at page 14. It relates to the process of selection of mates. In the MES, lordship. And here.
Two 2019, see the order.
Yes.
The entire selection process was interfered.
Lordship. Now, what I am on is lordship. Some allegations have been made. They were made in the OA regarding some candidates who had appeared in two centers, lordship. And these people were not even made a party before the learned tribunal. And secondly, lordship, the tribunal went into the aspect of lordship.
Can we ask you, what is the status of the selection process? It has been concluded?
It has
or
been concluded, lordship, they are working. Those selected candidates are working. And this OA was filed after the selection process, after these people were working, lordship.
Is there any notification circular saying that a candidate has to give a choice for the center?
In the advertisement, there was a clause that he can apply for only
at
one center.
one center?
And on the last occasion, lordship had directed me to get the list of applications where I could find out who were the people who were applied in two places. Lordship will see my affidavit, which I have filed pursuant to lordship's order in September 22. Here, lordship, we could find.
Please.
Yes. Candidates are now working at different places without hearing them, whether we can check the election process. We have the impact of the working. These are parameter appellate reports. Finally. But they would have got one vote. In the meantime, has any new selection process taken place?
No, lordship.
No,
No, lordship.
because 4 years is fairly a long period.
It's a long period, and what lordship subsequently from the authorities, what I could find, and I placed it on affidavit. There were 4 candidates who had in fact applied for more than one
center.
more than one, lordship. And under such a situation, lordship, if they can be identified, lordship, the law is well settled. If they can be identified, they may be weeded out.
They may be.
They may be weeded out, but interfering with the whole selection process, lordship.
Now this para 14 of the CAT's order, CAT committee,
Yes, lordship.
there is a finding on fact that similar questions for both centers have been admitted.
And different dates.
I would just pause here for a moment, Lordship. What has happened here is, once the examination that was supposed to be held at Dimapur and subsequently held at Narengi, the earlier question papers were destroyed, which I brought on affidavit, Lordship.
But there is an admission before CAT.
Yes, Lordship, some questions may be similar. It is not like questions are not repeated.
Verbatim, they were not same.
It were not same, Lordship.
No, your page 103. Is it the WS file before the CAT? On behalf of your writ petitioners as respondents?
My Lordship, written statement is at 103, yes, Lordship.
So this is the WS referred to by the CAT,
Yes, Lordship,
where reference is made to para 5.
Lordship.
Is there any admission in para 5 to that effect?
Also.
Lordship, also while a few questions were found to be similar,
Majority of questions are different.
different, Lordship.
Question.
There may be repetitions, Lordship, it is.
But
Even
have you
when
been able to identify those candidates who applied it?
that I have brought on record by way of my new affidavit.
How many candidates could you
Uh,
find?
Lordship, if your Lordship will take paragraph 4
4 candidates.
of my affidavit.
Affidavit in opposition? No.
No, it's an
Page 126.
additional affidavit. Subsequent to the court's order.
Continuous page initial 124.
Appellants.
Yeah,
Yes.
para 4.
Paragraph 4, the deponent begs to state that on scrutiny, it is further revealed that Subhankar Lohar appeared from 137 WE under so and so, and he also appeared from before CWE Shillong under so and so. He was selected and appointed under 137 works engineer. Pranay Kumar Roy, Lordship,
Para 6 again. They have explained that the first set of question papers got destroyed and a fresh set of question papers got issued for the postponed examination, rescheduled examination. We can proceed on that. We can take action. That would give rise to another set of litigation. Give them liberty to take action.
Appearing for the respondents, Mr. Amit.
Lordship, these 4 people go. If they are otherwise eligible, maybe, Lordship.
My lord, regarding the Lordship, kindly page 69 of the recruitment. Page 69 of the recruitment.
Yes.
Scheme of examination. There is objective type and multiple choice question only with negative marking. OMR sheet was not given. Who is the common practice under central state government? Prescribed question come answer sheet to the post of mate. But in this case, page 21 judgment para 10, as pointed by learned tribunal, the candidates were provided on simple faded Xerox paper, type paper, which it can be easily changed replaced. This was admitted by the instant in the
You are reading from which page?
Page 69.
69, Lordship.
Of a read petition.
The learned tribunal has gone into the aspect that OMR sheets were not given. It is not a requisite under the advertisement, Lordship. It can be any other mode, Lordship. Had it been only OMR sheet.
About 10,000 candidates appeared. It is not possible to mechanically.
Whether it is possible or not, it is for them to see. They might be having that workforce to examine the handwritten and answer sheets. What is the problem over that? Does the scheme prescribe for OMR sheets?
No,
If the examination notification doesn't say that it has to be in OMR sheets, we are no one to interfere. That is a policy decision of the exam recruiting authority.
Objective type question is there in base.
Objective type, why can't it be in a vernacular language or typed language?
Yes.
Why it is required to be an OMR? OMR is only for the purpose of facilitating the assessment after the examination is done. a computerized machine scans and makes the assessment here. But they don't require it. They have got enough invigilators or
Another-
examiners to check the question
Another
papers.
thing is that, my lord, that
They might be banking on obsolete technology.
the page
Even the
20
Guwahati High Court is doing it.
my lord, page 72, Lordship, kindly see, page 71. Here of the attention is made to applicant to note that the area which the applicant wish to apply may need to be specified applicable column applicant will be considered only for particular children. But in this case,
That is
That
what I have
aspect, we are saying that 4 persons have been identified. We will
more
leave them
than
to,
four. Lordship are
sir, they have filed a particular affidavit. We will ask them to take action against those candidates. So if your candidate has secured that number of marks by elimination of 4 or 5, your candidate gets in, he will get in.
and another thing is that the similar it is a competitive examination. 1 or 2 question paper is valuable.
You have to demonstrate, sir, that the question papers were exactly the same.
They have put that.
They have said that some were similar.
Yeah, some are similar.
So how does
So-
it make a difference?
My lord, 1 or 2 mark is
For
very
that
much
purpose, sir, for that
important.
purpose, we are giving them the direction to take action against those candidates who have appeared in both the examinations, contrary to the guidelines. We'll give them direction.
and
So if they are ousted, if they are shunted out, your clients will get the opportunity.
then that my client may be allowed to appear in the exam by
That-
relaxation
That will
of
be
age.
on the merit position, Lordship.
Relaxation
In
age.
that earlier examination, whatever the merit position of your client was, we will give them the direction to consider you in that situation. If 5 people go out, the merit list changes. Though waiting lists can't be operated after so many years. But since the CAT has interfered in the examination itself, we can, in a peculiar set of circumstances, give that direction. But relaxation issue, that is up to the authorities. But so far as interfering on this ground that OMR examination sheets were not provided, it is not there in the examination scheme of examination. You are supposed to challenge it before participating. Law is well settled.
Yeah.
That once a candidate participates,
And
then he
no-
cannot challenge the terms and conditions of
My
the.
lord, no change of center of examination will be allowed. The page
That,
69 and
I'm-
272.
I'm coming to that, Lordship.
They say that due to law and order problem, they are working in military. That what law and order problem,
How were you prejudiced, sir? Your clients appeared in the examination.
change scheme that advertise contrary to their own stand. Advertisement.
What is your explanation to that?
Lordship, what has happened during the relevant point of time, Lordship? The situation in Nagaland was not very conducive, Lordship.
No,
And for that purpose, if I accept my learned friend's submission that we being in the army, it is very safe for us, it is not safe for him.
You
It is
were
not-
more worried for the safety of the
It is not
candidates.
Therefore, it was taken out from Nagaland and it was done in Narengi. And we have really admitted that in our written statement also, Lordship, due to the conditions of that. Otherwise, what business would we have to?
Hmm.
And if those are vacant, and these people can be moved up in the merit, then we consider there is they would be becoming oriented. That is. Of course, it's now. Maybe. Yes, so yeah, yes. They can merit that maybe next 4 or 5 years, they would separate. May not. They would have. That is all we cannot.
Okay. Then we admit the matter will require some amount of hearing. Heard learned counsel for the parties, admit list for hearing. After 4 weeks,
Interim order dated so
interim order dated so and so will continue.
it's confirmed to last disposal of the petition.
Date may be in the month of April.
We have given it up
4 weeks.
It will come up.
Closure.
Item numbers 9 to 12.
May it please the Lordships. My lord, this is a review petition. Actually, what happened, my lord? None of the petitioners were before the learned single judge, my lord. Along with the prayer of some master roll laborers, my lord, who approached the learned single judge. Initially, my lord, there was an order that the services of the master roll laborers should be regularized. And in fact, pension also should be paid. Against that, my lord, state preferred an appeal. Now, that appeal was disposed of, my lord, taking an undertaking, not an undertaking, my lord, sort of a concession was given by the state that until the age of superannuation, we'll retain these employees and we will give them the minimum of the pay scale, that in terms of that Supreme Court judgment, my lord. So that is how, my lord, the matter was closed. But my lord, our perspective is we are work charge employees. Work charge employees and master roll workers are distinct and different.
Has there been no scheme of absorbing? Astan, they absorb all.
Here, the
Has
absorption,
there, the state of Assam not adopted any scheme for absorption of work charged employees?
In fact, my
There
lord,
in
it was
Rajasthan, they have
done.
done.
At one point of time, it was done, my lord. Subsequently, in fact, at that one stage, more than about 23,000.
35.
About 35,000 odd master roll and work charge employees were, my lord, absorbed and they were regularized.
So why these
And
people
they-
were left out? Why your clients were left
My
out?
lord, actually, our case is slightly different, my lord. From the very initial, we are getting everything other than pension.
Mhm.
So our claim is, my lord, we should be paid pension.
So you already crossed the age of superannuation.
No, we have not crossed, on the verge of crossing, my lord.
Okay.
Now, in fact, my lord, if your lordship would kindly permit me, I'll just place one paragraph. Why we had to come in review application. If your lordship would kindly come to page 200, my lord,
Page number
200,
100.
200, yes, my lord. This is
Which
our,
file are we are,
Read appeal.
no, lordship is dealing with the review petition, my lord. Review petition 150 of 2019.
review petition file. What is the appeal about?
In the, my lord, in appeal I am there.
Ajay, you are there. Okay, let's first take up the review then.
Yes,
Before Lordship proceeds, I would like to place only one thing. The judgment which is delivered by the division bench. Some parties have already approached the Supreme Court and the SLP is presently pending. The same judgment. I have the copies of the order also.
my lord, no, my lord. In fact, this submission
They can go before the Supreme Court
No,
and
my
get them
lord,
implemented.
This argument was made by my learned advocate general on the other day, my lord. We have verified from our clients, my lord. Our case is totally different. That's, my lord, we are not against the judgment as such. All that we are saying is we should not have been covered by the
Mr.
judgment.
Chaudhary, to cause interference into the judgment when Honorable the Supreme Court is seized of an appeal
Exactly.
against the very same judgment.
No.
And if they have a different,
No, my lord, master rolls have gone. We are work chart. My lord, there's a Supreme Court judgment which says master rolls are different, my lord. I'll place the judgment, my lord.
then they can have a separate cause of action to file a writ petition.
No, our cause has been frustrated by the judgment. We are not even parties. Please, that's why I was trying to draw your lordship's attention to page 200, my lord. Para 11.
00.
200, yes. Para 11. The petitioners further beg to clarify that the petitioner association is a registered and a government registered one. Surprisingly, neither it nor its members have ever approached the Honorable High Court or we even implemented arrayed as parties in the aforesaid series of litigation claiming for regularization. This was due to the simple fact that although the petitioner and other workers employees may have been temporary employees of the state, yet their service
So you are
condition
reading
rules.
from the pleadings of a review application.
Yes, my lord.
Filed by
Us, my lord.
the present review application.
Yes. Page two
So
hundred.
you were not a party in the writ petition.
No, not neither in the writ appeal.
So why the judgment hurts you?
Because it says, my lord, that master roll and work charge are not entitled to pension, amongst others.
311 to code.
No, no, put it. So
Let
I'm
us
just
see, let
reading
us see the order, please.
Oh, yes, order.
311 to
My lord will kindly come to page 311. Para 22. It is, however, heartening to learn that the state government has agreed not to terminate the master roll work charge and similarly place employees working since last more than 10 years till their normal retirement, except on disciplinary ground or on the ground of criminal offences. The state government has also agreed to enlist such employees in health and accidental and death insurance scheme, which will be prepared in consultation with the state cabinet. We appreciate this positive stand of the state government taken as a welfare measure for the betterment and security of the employees in question. We accordingly direct the state government to implement the measures without further delay. Besides this, we, in the light of the decision of the Supreme Court in the state of Punjab versus so-and-so, also direct the state government to pay minimum of the pay scale to master roll workers, workers, and similarly placed employees working since last more than 10 years with effect from 1/8/2017. For these reasons, we are of the view that in the fact situation of the case, master roll workers and casual workers are not entitled for regulation of their service with consequential benefits such as pension, etc. Well, there are state government circulars which says workers are entitled to pension.
How do you satisfy the court that the petitioners who were there before the division bench in that writ petition
Yes.
were only work charge employees?
No,
Because-
they're mostly master roll
Oh, only must read para 2, please.
of the judgment, my lord.
Yes,
Yes.
the core issue which calls for our consideration is whether in the
Yes.
fact situation of the case,
Ah.
the respondents who are master roll workers, work charge workers and casual workers.
Yes.
So all were represented, sir.
My lord, we were not there, my lord.
No, what is the
This paragraph,
My lord, to the best of my,
a particular set of work charge employees
why-
may not be before the court,
my lord, why?
but
we-
they were there in
No,
representative
my lord,
capacity.
why we are not represented? I'll give an example, my lord. My lord, we are entitled to regular scale. We are getting everything.
Irrespective
Our
thereof,
prayer is only for
They-
pension.
They were there in representative capacity. Even if one work charge employee was made a party in that writ petition or the writ appeal, you were very well there. So the remedy for you would be go to the Supreme Court, seek
No.
a clarification, let us agitate our cause independent of the findings.
No, my lord. We were not there for the simple reason, my lord. Our prayer was never for regularization. The basic prayer in the application
Then
was for it.
we'll have to see the pleadings of the writ petition now.
Yes. Petition को आसान नहीं है, हैं? Lead petition को याद नहीं निकी, हैं?
AG sir, are you having the writ petition with you?
Petition को. My lord, can I do one thing, my lord? Can I bring one compilation in the form of the pleadings, my lord? That will be helpful.
Precisely, we'll have to see what were the pleadings in the writ petition, what was the profile of
My
the
lord,
petitioners.
In fact, my lord, if your lordship would kindly permit me to place two documents, there is a compilation given by us, my lord. If your lordship would kindly come to page number 45 of that compilation. Page number 45.
Yes.
It's an OM dated 12th of September 96. Has your lordship got it?
What do you want to say from that?
The government's policy decision to give.
Irrespective, in spite thereof, a certain set of work charge employees come to this court saying that we are not being paid our dues. The court says you are entitled to only this thing. And whether another set of work charge employees can be permitted to make a different prayer contrary to the judgment of this court.
My
In the
lord,
review,
whether-
in the review,
whether-
particularly when the matter is before,
No.
subject is before Supreme Court.
Supreme Court, my lord, that aspect we have tried to find out. What we find is, my lord, some master role workers have gone.
We don't know, sir, because reading this para 2 of the judgment, it comes to light that all kinds of workers were there before.
My
this
lord,
court.
it often, my lord, MRN workers, these expressions are used very loosely, my lord, without realizing, even us, my lord, we used to.
Once, sir, the matter is before Supreme Court.
No, no.
Even if it is used loosely,
If a
without
matter is
proper
before Supreme Court,
confirmation,
if a matter is before Supreme Court, certainly not, my lord, will not ask your lordships to adjudicate on
better
the
seek a
issue.
permission, get an intervention in this matter pending before Supreme Court. That would be better.
So what I propose to do, subject to what your lordship may say, my lord, first, we'll place the repetition on record by way of a combination.
You first
And also
satisfy
try to
yourself.
find out, if
First
my
satisfy
learned friend
yourself.
can help us with these orders of the Supreme Court, my lord.
And the other day, I think we have given a set of copies. So I'll repeat it, lordship. I'll give another set. I'll do it.
Otherwise also, sir, you are not in the habit of exchanging emails, it seems. So pass on another set of physical
Yes,
documents.
we'll WhatsApp also.
To keep the proof. My lord, in fact, government policy is already there, my lord.
All said and done, sir. If the thing has been already dealt with, in the case of work charge employees, your stand that we were not heard.
No, my lord. Why the prayer for regularization will be made when they're already on the regular roll? We're already on regular.
You
Only
yourself
thing is,
say
my lord,
that you are getting the minimum of pay scale,
no, my lord, we're getting scale.
regular pay scale.
That's why I wanted to show this compilation, my lord. Please have a look at it.
Simple thing for you would be to get a clarification from Supreme Court.
Yes.
Please count us out of this judgment. And then leave us at liberty
So
to
we'll agitate before the High Court.
pension.
Yes, that
No,
is.
provided, well, let me find out, my lord. We'll find out, then we'll get that.
Find out, we don't pass any order, simply adjourn the matter.
For 2 weeks, my lord.
Oh, yes.
Oh, dear.
As prayed list of 2 weeks.
Highly obliged.
Yes, we'll take up your matters. No, but they are tagged together, sir. What to do? They are all connected.
In fact, in our first round of hearing, in these cases, my learned friends, it was almost to be dismissed. At that point of time, the workshop, my learned friends, Chaudhary
I
entered.
have a good case why it will be dismissed. That is my thinking, my lord. First thing, my lord, we are workers employees. Here are two appellants. Appellant number
Mr.
one.
Chaudhary, Mr. Chaudhary, my lord, now things are very clear. These are two appellants before this court who are work charge employees. So definitely the work charge employees were before the writ court. That is now a surety.
We were before the landed single judge and single judge dismissed the case. But the same single judge has provided relief in other cases. I will
In
show
the
all those.
judgment which is in review,
No.
Oh, that is,
Some
the-
other-
I have no
some
idea.
other judgment. All right, let us see.
I think
Let us see your file.
they are in respect of some other case arising out of
cases.
another judgment.
Totally
Other
other.
set of litigation. So we detach your files with from this review and hear you independently.
Yes,
The
that is.
the bunching is not just, what do you say, sir?
Exactly, lordship.
Now, one thing, my lord, it should be hard because, my lord, first thing, our husbands,
We will hear you. We
who
will
are
hear you.
the
Yes.
workers employees, my
The
lord,
hearing deputy officer.
We will hear you, but let us detach the files from the review.
Separate the hearing.
Just hold on, please. What is the judgment in the review petition, date of judgment
I don't know
and the writ number?
why.
My
My lord, if your lordship is a very short date, because my husband died, I am also on the way to go. If we both of die, what will be the purpose of filing appeal?
Hold on.
Some people.
This is a fresh appeal out of a single bench judgment.
Yes.
right.
So it has no connection with that review petition.
When this was heard, lordship, then my lord, my friend Chaudhary entered into the scenario.
Likhe, the controversy raised in these two writ petitions seems to have no direct connection with the review petition number so and so. Thus, these files shall be detached and listed separately. Next week mein laga dijiyega on 12th March.
12.
Yes.
May little bit upgraded, my lord. We are very poor. Old men, like our husband already died and we are also lying in bed. So if some benefit is not provided, nothing is paid to us.
Whether benefit will be provided or not, that will be seen after we hear
That
the
is our
state.
expectation, my lord.
Yes, of course.
Highly obliged, Lordship.
12th March.
Matter number 13,
Yes.
May it please, Lord.
Yes, please.
My lord, the challenge before the learned single judge was against the decision of the appellant FCI to recover the overpayment, or excess payment made to the contractor against his transportation bills. The petitioner was appointed as transport contractor for transportation of food grains from the railway siding at Jorhat to Shivsagar depot via the way bridge. My lord, it was the terms of the contract that the payment would be made, my lord, on per metric ton, per kilometer basis. My lord, at per metric ton, per kilometer basis, my lord, and on the net weight of the food grains. Net weight, so if he transports 1 kilometer, for the, then he'll be paid 1 kilometer. Distance is given. Now, my lord, the petitioner claimed that he should also be given for the distance covered by empty trucks. My lord, the truck is to go to the way bridge, then to the railway siding. So this is 6 kilometers. He also claims where the terms of the contract says on net weight basis payment would be made. That was the dispute.
Regarding payment, I think. Here it's 20. This will put them in applicable different down. Which is
There any arbitration clause?
Well, there is a provision for in-house grievance redressal committee we have in our zonal office. Even the Supreme Court very recently.
No, in the contract, what is your dispute resolution clause?
My lord, will kindly come to page set of conversion. Page 118. 118.
FCA.
Clause 20.
20.
Clause Roman 20, page 118, 118. Down below, my lord.
Clause 20.
20, my lord. B especially.
Disputes arising out of and touching upon the contract.
Was it placed before the dispute
No,
resolution?
my lord, it was not. They have approached the.
Oh, you were referring to some Supreme Court judgment.
No, it happened like that. This honorable court, my lord, recently has passed an order in the, my lord, lordship has passed directing us to adjudicate the matter. This order was taken before the Supreme Court. Supreme Court, the adjudication should be made by the grievance redressal committee.
Let us
That
have
was
the
the order passed.
Please bring that order.
No, it is just a copy.
The reversal committee will not consider the whole grounds.
Who's appearing for the respondents?
My lord, I am for the KV as the responder.
Yes.
There are a number of cases I conducted where High Court district, what is district redressal from?
No, the
We are-
first thing we'd like to know is why are you apprehending that the dispute resolution committee or the cell,
Because we don't have a dispute. What I am challenging is an illegal and.
but then you are before the court.
No, let me. What I am, my lord, challenging in the writ court, my lord, first court was the illegal arbitrary action of retrospective recovery of certain amounts in respect of works that was completed 4 years ago. It is the action and violation of the principles of natural justice. And also number of decisions.
The contract had come to an end. Contract
Contract came to
concluded.
end for 4 years ago. Then suddenly, my lord, can I put forward? The payments made.
So essentially what you're saying is dispute resolution is there when there is a contract is subsisting.
No dispute. And these are the cases, my lord, this High Court on day-to-day basis, my lord. And
We will examine the law. We are only asking about the facts, just to have a
4 years
clarity.
ago. 4 years
Just-
ago. 4 years ago, contract concluded. Then suddenly, behind my back, they gave me a retrospective, my lord, recovery without any giving any opportunity to me to confront it. Purportedly on a report of the CAG that they made excess payment. Now, my lord, kindly turn to my case is what? Kindly turn to my lord.
You contend that under the clause of the contract,
My lord.
there is a specific clause
lord-
which permits recovery.
Yeah, I'll come to that. Lordship, kindly see the notice invitation tender,
They should have gone for it.
which your lordship will find at page 52. They are recovering.
Yeah, we have to put them to.
But
Yes.
Yeah, the contract is over. What do you say, sir? Contract was concluded 4 years back.
My lord, lordship.
The same way, just hold on, sir. The redressal, if you are at all referring to the process of redressal, you had a grievance that some excess payment had been made. You should have gone to the redressal committee. Why not?
Right, the lordship is right, but before that, they have closed the court. Now, my lord.
They approached the court because you directly proceeded for recovery.
My lord will kindly come to page 20, provision of section 28B of this was raised in the earlier last case that I've shown. And this honorable has taken note of it. Said this determination should be made. My lord, I've got the order of the division bench, last order. This plea was raised by us, saying in view of the provision of section 28B of the Indian Contract Act, we can make a cover. My lord, kindly have a look. Section 28B. 28B, I have raised this plea, my lord. We can do that. That doesn't forbid us, because maybe the contract was completed. But that doesn't restrain us from making the recovery, my lord. So asking for the money. 28B provision was, well, lord. Same plea was taken in the last case, my lord. It was also concluded contract.
Having examined the aforesaid contentions raised by the counsel for the appearing for the parties, the fact remains that deduction of rupees so and so relates to two different contracts under which the appellants have operated as per clause 29 of general conditions. The fact remains that there is no adjudication so far as the amount due and payable, if any, by the respondent original petitioner is concerned.
Right.
Merely by issuing a notice, the same cannot be done.
That is all right, my lord. That is why the adjudication was directed in view of the provision of section 28B. There are also two contracts. This is also a two contract, my lord.
This adjudication has been done pursuant to this order.
My lord,
This order refers to the same contract or what?
No.
The order you are
It was a
citing.
different contract, but
So,
similar.
Where is the
similar.
adjudication?
We also sought to recover, but not in that case.
So
Similar.
in the present appeal, where is the adjudication by you?
That was not that. That's why, my lord, I say, Lord, let this be adjudicated. Lordship will direct the grievance.
Why should we do so, sir? You are at liberty. You want the things to be adjudicated. It is for you to approach the appropriate forum.
My lord, according to us, we made the
You
report.
can't act as at your whims.
No, my lord, what
Say,
happened,
I will recover this much from you.
my lord, what I submit before Lordship is
Yes.
that the Lordship will kindly appreciate one thing, that the money that has been given to him neither belongs to the payer nor to the payee, but it is the state money, it is public money. So that was paid in excess.
Irrespective, there is a mode of recovery provided in the civil procedure code. File a civil suit.
Yes.
No, it's true, my lord.
Go
but
for a
that-
money suit.
No, my lord, your lordship is right. But it's true, my lord, that my lord, the proper adjudication was not made. So at this stage, your
Then you are
lordship-
trying to justify the officers who are incompetent.
No, my lord,
By filing this appeal,
But-
you are trying to save the officers who are incompetent to hold the positions.
my lord, maybe there was a fault on the part of our officers.
Yes,
It is true, it may be. But the money taken by him is, my lord, doesn't belong to him or not belong to us, my lord.
who are you to say so, sir? That is for the adjudicative forum
That's right.
to decide.
No, my lord, that's why I've shown to your lordship that the payment was required to be made on the net one, which is not an empty truck.
We are not at all going into the merits of the matter. What is the process prescribed by law for effecting such recovery? Only that is what is our concern. Whether you have adopted the process or not. Withdraw your appeal, say that we will adopt the appropriate process prescribed under law. We'll give you that liberty.
To go before the grievance redressal, lordship.
Whatever process, if
Lordship.
grievance redressal is appropriate, you adopt that, they will have a right to resist. If a civil suit is to be filed, it is time barred now. So you are going to the grievance redressal cell also will be hit by the provisions of Limitation Act. Because the recovery sought to be made is beyond 3 years. What you will do now?
No,
That is why this modus was adopted. To avoid being hit by the Limitation Act.
All right, we'll avail our whole remedy, my lord. Lordship will.
If I am permitted, I'll just show Lordship two documents. Look at the tender notice of 2015. 10,000.
Sir, we are not going to the merits. We'll say that if at all they are inclined to make any recovery, that has to be done as per law.
Go for money suit, not even
Whatever-
redressal forum.
Whatever procedure,
Yeah.
if they adopt the redressal procedure, your cell or forum, then you will have another opportunity to file a fresh writ.
It is not for
So-
your Lordship to suggest where
We
they
are
should
not
go.
suggesting at all.
Lordship will dismiss the writ appeal, that's all, my lord.
No,
They will gracefully withdraw it.
No question of giving any liberty or any, my lord.
No, liberty we will give. After all, it is public money which is involved.
You are withdrawing the appeal?
Draw, my lord. Lordship will grant me reward.
Finding of the.
Yes. If at all the appropriate. Finding will not be noticed.
And they are recovering from the another contract.
I heard Mr. P.K. Roy, Learned Senior Counsel, assisted by Mr. So and Mr. A.C. Borbora, assisted by M.S. So appearing for the respondent caveator. This appeal filed by the FCI is directed against the order dated so the learned single judge. The learned single judge interfered with the recovery sought to be made and by the FCI and allowed the writ petition filed by the respondent caveator, full stop. Aggrieved, the FCI is before this court. During the course of the hearing, a reference was made to clause 20,
Lordship.
Roman 20, page 118, which reads as under. Extract clause 20. In terms of clause 20 within bracket B, there is a reference to a dispute/grievance redressal committee constituted and functioning in the zonal office of the corporation, which shall settle any disputes arising out of the contract. Para. Having perused the pleadings on record and upon hearing the learned counsels for the parties, we find that the contract which was offered to the respondent by the order, where is the
Page 30,
LOI?
page 30,
Appointment letter is page 55,
page 55.
3/8/2015.
By the LOI dated 3/8/2015
Yes.
pertaining to so-and-so work was duly executed by the respondent
For 2 years.
within the times specified. Full stop.
And it
The
was-
bills raised have also been released.
It was concluded in 2017.
Full stop. The said contract was concluded in 2017. Full stop. Pursuant thereto. Where is the impugned letter?
Impugned letter, your lordship will find at my lord page 32.
2020.
Page number
32.
32.
My lord, paper book, my lord, 57. Say,
By the letter dated 16/5/2020.
yes, only copy was, everything was decided, my lord, behind my back.
The appellant directed the respondent the appellant withheld an amount of rupees so and so
From another.
from the running bills of May 2020 and June 2020
From
Towards another.
entirely different contract.
as per the direction of the regional office. Full stop. Being aggrieved, the writ petition was filed. It is the submission of the learned counsel for the respondent that this amount sought to be withheld relates to another contract which is being executed by the respondent. Full stop. Upon careful perusal of the provisions of the contract as well as the impugned order of the learned single judge, we find that the provisions of clause 20 of the contract ought to have been resorted to by the FCI. The clause 20 equally apply to both the contracting parties, including the appellant, the FCI. Full stop.
During the existence of the contract.
Such application of clause 20 of the NIT will apply to both the parties during the currency of the contract. Full stop. Be that as it may, during the course of the hearing, learned senior counsel appearing for the FCI submitted that he'd like to withdraw the appeal, seeking liberty of this court to approach the appropriate forum, including the dispute grievances redressal committee.
My lord, may I submit, my lord? 1,20,000 crores are blocked.
Full
Hold
stop.
on, hold on. Hold on.
Upon such submission by the learned counsel for the appellant, we permit the appellants to withdraw this appeal and approach any competent forum as per provision of law. The findings of the learned single judge will not come in the way and will not be a hurdle in approaching the relevant or the competent forum as deemed appropriate under the provisions of law. The appeal is accordingly dismissed with liberty as permitted.
My lord, may I just
We'll have to clarify arising out of
We have
contract.
already done that.
So the language is arising out of and touching upon.
Sorry.
May I just point out one thing, Lord? We have done that. Well, our senior said that it is the contract is ended. We have done that, page 116, my Lord, you kindly have a look for it. We have done that under the provision of clause 14, Roman 14, place 116.
Set off.
Lodging, under this contract or any other contract.
It's okay. We are not restricting you
That's
from
right.
making the recoveries, but follow the process of law.
That's right, we can do that.
And my lord, about my lord, release of my lord, security deposits and everything. I'll be deprived, my lord. Naturally, they are not going to pay now. They will, virtually, my lord,
Other contracts are subsisting.
virtually, my lord,
They want to recover the benefits.
Since you are withdrawing the appeal,
My Lord will give
there should be the full stop, my lord.
since you are withdrawing the appeal, you'll have to comply with the learned single judge's
No, my lord-
directions
my lord-
so far as the release of the payments are concerned.
My Lord, will give a time frame to approach the forum, my Lord, that will be decided, my Lord, within 6
No,
months.
but why withhold, sir? This is a contract of 2015.
And
We are giving you that liberty that is quite sufficient.
he is
So you
still,
can't withdraw, you can't withhold the amount
he
at your whims and caprices.
is withholding 1.2 crores, my lord. How can I survive as a
And
poor business?
the contracts are still continuing. You have not blacklisted the contractor.
No,
So the opportunity will be there to make the recoveries.
That is what we have done, my Lord. That is what. we've
So
done.
that is what you have done prior to a
Under an
finding.
illegal action.
Prior to a finding that this amount is required to be recovered, there has to be a finding on that.
That's right, my Lord. But my Lord, according to us, that it's already, he has a prior notice on that. That he knows if he
no,
receives. it,
never,
he
never,
has-
never, never. Everything was done behind my back. my lord.
Notice would not serve the purpose, sir. There has to be a proper scrutiny.
That's right.
There is no scrutiny at all. And once the scrutiny is made, heads will roll in your corporation also. So this is not the only consequence of the recovery. There has to be a corresponding action against the erring or maybe even colluding officials.
And with this handle, my lord, they are going to withhold for my lord, yes.
So we are directing them that in view of the withdrawal of the appeal, the direction of the learned single judge for release of the payments shall be complied with.
Yes,
Sir,
precisely.
That's right. Much obliged.
Turn numbers 14 and 15.
May it please your lordship. My lord, this is the appeal, my lord, transfer from Manipur High Court to this Honorable High Court lordship by the Honorable Supreme Court lordship. And my humble apology, my lord, last year of hearing we could appear for that matter because we didn't have the intimation that the matter was listed on that day, your lordship.
No issues, no issues,
Yes, my-
please.
My lord, there is a caveat, I don't know, nobody's appearing for a caveat, your lordship.
Have you intimated the other side?
No, my lord, we also came to know regarding this listing the day for yesterday and we rushed to
Okay,
this, your
okay.
lordship. I
So
don't know.
let the curator be informed.
Hmm.
And when would you like to argue the matter, sir?
Maybe I don't, and second, your lordship, second of this, because there's the urgency in the matter, your lordship, because it involves that, my lord, the game of hockey in the money, is the money, your lordship.
Mhm.
Yes, your lordship, you're fully aware that even though it's a small state and lesser populations, this is, people used to consider the state, the nation considers the powerhouse of sports, your lordship. Lots of hockey players, all
We
Indians
know,
have
we
been
know,
produced
we
by
know,
the state
we
of
know.
Manipur, my
Yes,
lord.
yes.
Because of litigations, my lord, those, my lord, players, they are not able to participate in this, in most of the tournament losses.
So these have been transferred under directions of Honorable Supreme
Yes, your
Court.
lordship. And during the, my lord, during that pendency of the transfer petition, the Honorable Supreme Court was, my lord, kind enough to give the status of
Okay.
my lord, order, my lord, he passed it, my lord, maintaining that the status
And
quo,
counsel, what's your good name, sir?
my Sapan Biswajit.
States that. Who has entered caveat? Can you name the counsel, please? State of Manipur
One Hemchandra, your lordship. Yes.
has entered caveat
Yes, ma'am.
in this matter. The caveator be intimated to remain present either personally or through counsel on the next date of hearing. List on second,
Yes.
or can we have it up 10th after 11th?
My lord, it's an urgency, your lordship.
You have a
because-
stay in your favor.
No, my, but there is some difficulty, Lord, your lordship, to be very frank, your lordship. The Supreme Court, my lord, on the last day of transferring the order, my lord, there's silence regarding the status quo, my lord. Even though the status quo was passed in the
In
initial
the first
stage.
date.
Yes, my lord.
On second, all right, we'll have it on second.
They will rise.
You are from Manipur?
Yes, your lord.
The caveat is also
Yes,
counsel
my
from
lord,
Manipur,
yes,
so you
my
can
lord.
inform them.
Yes, madam. We'll inform him. Yes, we'll inform. In fact, we were expecting that they would be appearing today, your lordship. Yes, also, we also came to know regarding this matter on only on Saturday. We rushed yesterday, your lordship. I'm so sorry, my lord, for that, your lord.
It's okay.
You will oblige me.
Nothing.
Item number 48 of supplementary list for admission.
May I please your lordship? May I please your lordship? I have. By
Is it
the.
wrongly listed? That one. Get this file. If you want to have a look at this file. File is there with you. Bring the file. Bring the file.
May I please your lordship?
Yes.
Lordship, the learned single judge lordship, set aside my 6 years old abrogation letter, abrogation order lordship. The learned single judge set aside my abrogation 6 years old abrogation order saying that the private respondent, the petitioner here, private respondent is senior to me lordship. And
Oh, right. This is 49.
And consequently, lordship, an order of recovery has already been passed against me, lordship. From myself.
The matter has been remanded by the learned civil judge.
Yes, lordship, and consequently, an order passed where recovery is directed from my salaries, lordship.
Consequent to the order of the learned single bench.
Yes, lordship. Last page of my 68, last page of my appeal, lordship.
The order was passed in June 2022.
Yes, lordship, there was some delay, lordship, that was condemned by this honorable court.
Where is the order of the learned single judge?
Learned single
Page
judge
17.
order starts from 16, lordship, and relevant from 17, lordship.
We'll put the other side to notice.
No, they are on caveat,
No, I am-
lordship. They are in.
I'm appearing on behalf of the respondent or one, caveat.
Mhm.
I'm the petitioner in the case.
Right.
Who's for the government? What do you say?
Lordship, here there was another case wherein a grade 4 person was directed to be considered for promotion to the post of grade 3 in consequence with the ministerial service rules, Lordship. And accordingly, he was considered while considering for one vacant post, Lordship, the petitioner, the respondent here in the appellant, Lordship, he was considered, whereas that was in terms of the existing rule, without
Was not
considering the
considered.
other zone of consideration persons, Lordship. And since the procedure adopted by the district selection committee was wrong, Lordship, single judge remanded back for consideration under the existing rules, Lordship.
According to the government, is the respondent or the petitioner eligible?
Lordship, here appellant petition, here the appellant is junior to the petitioner, Lordship, of the writ
Writ
petition.
petitioner. There is no quarrel regarding qualification. That's what learned
Lordship,
single judge said.
qualification,
The respondent was not considered.
yes,
The writ petitioner was not considered
yes, Lord,
for promotion even though he was qualified.
yes, Lord.
Kindly look at the page 44.
What is that?
List lordship,
Seniority list.
and lordship, written seniority lordship page 47 lordship.
Yes.
And page 48, that is.
So the petitioner is senior to the respondent
Yes, lordship.
and he was not considered.
Not only senior lordship, he has qualified lordship, HS passed.
HS, he is also HS.
He is Madhyamik lordship. It is matriculation. Rules required lordship, HS lordship.
Read para 4 of the judgment.
Yes, Lordship.
His lordship, some mistake, lordship. I am-
Mistake?
Yes,
Are you sure?
I have seen lordship.
Pannalal Chaudhary.
Yes, lordship. If your lordship, I
The respondent is Kamal Bhattacharjee.
yes, lordship.
So he is also HS.
HSLC or equivalent.
No, HS.
And para 4.
Page 48.
Mhm.
So he is also HS. No. Kamal Bhattacharjee, page 48, you see.
HS lordship. And lordship, lead appellant is lordship, Madhyamik lordship.
Madhyamik Shiksha passed.
Is 14. And I am 10 years senior lordship.
So this is an apparent error in the judgment.
No,
Your
Lordship.
qualification is Madhyamik only, not HS. So you are lesser qualified than as compared to the,
No, both are HSLC, Lordship.
no, where is the qualification? Let us see. Page 48, please see. Service record, seniority list, statement of seniority.
Lordship.
He is senior to you. You are lesser qualified. How would you get the relief? You need to know the qualification of your client, madam.
Yes, Lordship.
He is not HS,
The required qualification is HSLC, Lordship.
irrespective.
Lordship.
The issue is that if there is an inter se issue of seniority,
Lordship.
then the higher qualified candidate gets the benefit.
Minimum.
And he's senior to you in the seniority list.
Yes, Lordship.
How you can be promoted in ignorance to the claim of the respondent, writ petitioner?
Lordship.
So that consequence has to follow. The judgment is right. There is no need to interfere.
But Lordship, subsequent to that, order of recovery has already been passed from my salaries, Lordship.
How long has he been serving? What is the
He
length of
from-
service?
He is from 98, Lordship. And in,
Because even if he is not promoted, there is 9 years, there is excellent thing. People to all the recipe is there. I don't know.
Is there any scheme for that ACP, MSCP?
Upgradation after a particular number of years.
Lordship scheme is there, but with regard to the grade 4 employees, Lordship, that I have to take in check.
That is applicable to all posts.
Yes, Lord.
Grade 2, grade 3 and grade 4 particularly. Where there are no proper avenues of promotion, these are called stagnation benefits. So stagnation, if the person has been serving for say 20 good years, he doesn't get a promotion, then at least he gets a financial upgradation on the next grade pay. To find out if that is so, under that scheme, the benefit of the next promotional post, at least financial benefits will be available. Maybe not promotion as such. Find out when will you get back to the court with that information?
Lordship, on next Monday or coming.
Okay, so we'll have it on 14th.
March, 14th March.
All right, madam, we'll find out if the benefit of financial upgradation can be given,
Lordship.
then your client will not be losing out at least on the payment he has received.
Lordship.
A promotion he will not get, that is for sure.
My lord. May I please, Lordship? Lordship, can it be listed after 20, Lordship? I have some difficulties, Lordship.
All right, Learned Government Council shall apprise the court whether the writ appellant is entitled to financial upgradation on account of stagnation in service. List on 21st March.
Lordship. Obliged.
The caveat is discharged. The item number?
Item number 49.
May I please, Lordship? My lord, this is a case where a small scale industry who was provided electric connection that was curtailed, disconnected on 22/12/2021. 22/12/2021. On the ground that there is some malpractice. My lord, our case is this, my lord. As per section 126(1) of the Indian Electricity Act 2003, if there is found any malpractice, then they should assess the amount and they will submit the same to the person concerned under section 126(2). Then, my lord, as per provision of 126(3), they may file objections. But nothing was done of this sort immediately, my lord. On the day of inspection, that is on 22/12/2021, electric connection was disconnected. There is an industry, my lord, Star Enterprises. The 45 workers work every day and some other related workers are also getting their livelihood from that. Since the year 2019, from the COVID start, we have suffered heavy loss. Here we have annexed 19 electricity bills. From that is, I have given a short note for your lordship's kind perusal. 2 copies I have provided. And if your lordship
You filed as per the judgment of learned single bench.
yes, now
You
lordship,
filed an appeal.
yes,
What has happened in that?
oh, we first, my lord, as though no notice was served to us, so we filed directly a writ petition. We did not go for appeal, though there is appellate provision. But as there was violation of principle of natural justice, we immediately came. Then the learned single judge, as a consensus order, asked the parties to go to file appeal and then come.
Okay.
Then we filed appeal, departmental appeal, in view of section 127 of the Electricity Act, my lord.
Right.
And they said you pay some amount. First, they are saying changing. We have already paid rupees 10,90,400. Even then, my lord, they are not providing electric connection. Our prayer was that we are paying this. You dispose of the appeal. Pending appeal, you give the connection. Otherwise, since last 1 year, 3 months, the industry is closed. Our condition kindly consider. Now, they have violated all provisions of law 126(1), 2, 3, and 126(5) says this. If it is not possible, how many days the person concerned has consumed the electricity illegally, then 12 months proceeding to that month. We were also said that you may also do this, but they have not done this. Now the learned single judge has passed the order showing different reasons that we have not paid. And also say we have said them to pay rupees 4 lakhs. Actually, we said that we have already paid 10,90,400.
So now the assessment is at 21 lakhs.
21 lakhs, my lord. Let me finish, my lord. So when they made assessment of rupees, my lord.
81 lakhs odd.
And
it was reduced to 21 lakhs.
21 lakhs.
Under an one-time settlement scheme, my lord, which has now expired.
My lord, they are on technical points, but they do not think that they have violated the provisions of section 126, 1, 2, 3, 4, and 5. 5 says that if you are not in a position, they have demanded that amount. But which is the period? They have not mentioned. And in the month of December 2021, our line was disconnected.
Right.
Prior to that, every month they visited our premises and later also visited premises and made the bills. We have paid the bills regularly. They did not find anything. Now, certainly one day, my lord, they came and alleged that we have used the line of villager. For your lordship's kind perusal, let me say, there are 250 kilowatts of line in that transformer. The villagers use 100 kilowatts and we use 150 kilowatts. Now, they say that we have connected our line with villagers' line to get rid of electricity. It is practically not possible, factually not, because the line will be blasted.
Why should we go into those disputed questions of fact, sir?
Yes.
Issue is that there has been an assessment, there is a demand, you opted for OTS.
Yes.
In that the amount has been fixed at 21 lakhs.
Yes.
Paid.
No,
That-
21 lakhs, my lord, that is the.
My lord, that scheme under which the assessed amount was reduced, my lord, that has expired. The mandate of the OTS scheme was that the entire amount that was reduced to 21 lakhs had to be paid at one go. They only made a part payment, my lord. Thereafter, they filed a writ petition saying that the provisional assessment that was reduced under the OTS scheme should be taken as the amount to be considered, and 50% of that amount, which is the mandate under 127(1), which is the statutory mandate of 50% deposit, should
Right.
be calculated based on the OTS amount. That cannot be the
That
case.
can't be done. It has to be in
My
terms
lord,
of the
without
original.
challenging the
provisional
provision of
assessment.
127(1), my lord.
No, my lord, that we are not to fight against them. First thing is this, my lord, their assessment was 84,49,581 the same day, immediately disconnected. Thereafter, their assessment was compound committee made 21,70,000.
Where is that assessment order?
So
Let
big
us see.
difference.
My lord,
Let us see that assessment
I
order.
have the original records, my lord.
Yes, please. No, they must have filed it.
They have not
Let us-
filed it.
Where is that amount of reassessment? Where is that order?
Yes, that is there. Reassessment order, lordship may kindly see. First assessment order 106, my lord.
Yes.
Page 106.
Yes, please. Compounding charges.
Yes, provisional assessment bill along with compound charges.
Yes.
So it was made 84,49,581.
Yes.
Now lordship kindly see, then thereafter we
Then you
moved the
went for reconsideration settlement.
settlement.
Okay, where is that settlement order?
That settlement order lordship would see page 109.
Yes.
Here amount was reduced from
So this
80,
is the resolution of the empowered committee.
yes,
That is binding on the parties.
binding on the parties, but thing is this. They say it is binding on us, we have not done this and that. What they have done? They have not followed any statutory
You should
provisions of
not have
law.
gone for the settlement then.
Now,
Once you are on the
My lord,
settlement, you
kindly,
are bound by the terms.
well, kindly appreciate that since the year 2019, from COVID, we are suffering. We have paid 10,90,400. So our prayer is this, you immediately give us interim connection and dispose of the appeal. What is the bar, my lord?
You're in appeal against which order?
Against both the orders, against the order of largest single judge, by whose.
No. The appeal before the department, appeal before the department.
They filed a
The appeal was filed, my lord. Yes.
109.
Appeal before the
That is
department, that
resolution
may be
that
seen, my lord.
So
The appeal.
They got the resolution. They don't want to abide by that.
Appeal was filed before the
2117. Let us see the provision, please.
My lord.
That
127.
is binding. 127.
Yes.
That is binding. That is
One-
what the challenge.
126, thereafter, my lord. And they have also given another police case against us.
Yes, they will definitely.
my lord,
They have to
there are
let us-
different-
Electricity, my lord.
There are difference. 126, 127, the police case, my lord, every act is not amounts to an offense. That is Supreme Court judgment is there.
There you will have a right to say it before the criminal court.
No, that will say, my lord. At first, our prayer is this since.
Whether
last
they have
1
filed
year,
any
2
appeal
months.
under 127.
They filed an appeal, my lord, before the appellate authority. That appeal has not been admitted because the pre-deposit has not.
Pre-deposit has not been made.
My lord.
What I'm asking, appeal against which order?
Appeal against the final assessment. my lord.
Final assessment.
What is the final assessment amount?
Final assessment amount of 84 lakhs.
84 lakhs.
You are not in appeal against this subsequent amount.
subsequent account amount because that was in violation of section 126(5).
Which is the provision for going to the empowered committee?
But that was a one-time scheme, my lord. That was.
There is a settlement procedure provided under your
My lord,
rules probably.
my lord, I do not have that, my lord. But I have the reports, my lord. Their application and the.
There is a procedure for settling these things through the empowered committee.
My lord.
Instead of going to the appeal, you call the party, go for an amicable settlement. That is what they have adopted.
My lord.
But now they want to file an appeal against this order. That would not be appealable. You have to find out the procedure, please.
My lord, that settlement, subject to what my lord holds. My lord, that settlement is no longer valid because the time period has passed, my lord. That
Oh.
period has elapsed. Now thereafter, what they're seeking essentially is reduction of the assessed amount so that they can make the 50% deposit based on the settlement amount and also reconnection, my lord. Whereas the statute mandatorily states, my lord, when in a case of electricity theft, 6 proviso to section 135 mandates that 100% deposit has to be made for reconnection, my lord.
Yes, yes.
My lord, they are saying this, but what the courts saying? Our high courts and so many high courts are saying what? I have given those points, my lord. Kindly see my citation.
Yes.
Page 3 of my outlines I have made, which I have submitted to your lordship. Kindly see page 3 bottom. Our high court has repeatedly passed order, it pays this percentage and there. Kindly see page 3 bottom. So many decisions in similar cases like 2014.
Sir, decisions after considering provisions of law.
Yes.
Please come out with the decision. Let us see. Where are the judgments?
I have given, it is given already. The judgments, yes, my lord. And if some judgments also have. Yeah. Now see one judgment, my lord, I am here. There's so many decisions in similar cases like 2014 SCC online Madras. Here, my lord.
Let us see. Let us
assessment-
see the judgment, please. Are you having a copy? Read the ratio of the judgment, please.
Yeah, ratio of the judgment was that there was the assessment of 1,20,085 rupees. And high court passed, they pay 25% and get connection.
That is discretionary order of this court, sir. Now they are having an objection based on the legal provision. You want to argue on those, please argue, satisfy the court.
In those cases, our high court has I have given you 4 orders of our high court.
Read, please.
Yes. Then lordship would say,
Which judgment are you referring?
so many, here, kindly see, page 4 are serial number 5. WBC number 2936/2016 of Guwahati High Court provided more relief than sought for. Then another lordship, kindly see 2018. SCC online Guwahati High Court 2062. Guwahati Court asked to pay 25% out of rupees 89,17,513. So this is our High Court's order. Then another High Court's order is there. WBC number 2942/2021.
Sir, you are arguing before a division bench. You are citing judgments of single bench
No,
in which
Supreme
there
Court-
is no consideration of section 127, please. Read one judgment wherein 127 is considered and then relief is granted, please. These are just judgments which we give on our whims. All right, let the party be given benefits.
My lord,
These are
one
all
thing,
those
my lord.
judgments, benevolent
My lord,
consideration.
kindly see the ratio of these cases and equity in our case. Repeated judgments is pronounced by our High Court. Now, why the present case that would not follow? What is the reason? They have not filed any appeal against those orders. So our, my lord,
We will deal with all these orders and pass an appropriate judgment. Whereafter this benevolent relief regime will be finished. You want us to do that, we'll do it.
and another judgment of our Jharkhand High Court, Rajasthan High Court are also there, my lord. So many, my lord, my submission is this. They are on technical points that we have.
They are on substantial point of law.
But
That appeal lies, you have to approach the appellate forum by challenging the assessment order.
we have filed appeal. But they
Make a
say that it's
pre-deposit.
50%.
Yes, has to be done.
That is to be
It's a
done.
case
my
of
lord. In
electricity
other
theft.
cases, they have not done this. In other cases, why my case is separated?
That is an incorrect statement.
So my submission, lordship, my only prayer is this. We have paid rupees, kindly consider.
You
that.
show us that in other cases, this issue was considered after due application of due consideration, there was a direction.
Those judgments are there.
Yes, please, with judgment.
Those are given. Those are given, well.
The first judgment you are referring to appears to be an interim order and the matter appears to be still pending. We don't know.
No, first Madras High Court order. Tell this first.
No, the first judgment of this court.
Of this code, that is serial number,
BDS Steel.
serial number 5, serial number 5.
No, first, number 1.
Number 1, High Court WBC number 2942.
Yes.
That here assessment was 1,90,000.
What is
1
this?
crore.
What is the status of the matter today? This order was passed on 11/5/2021.
Yes.
There was an interim order on a date when it was passed, the matter was pending. What is the status today? Is it allowed? Has it come to a conclusive decision? Is there any appeal, Mr. Counsel?
Yes, my lord, I have understood what is the last question. But thing is this here was 1,95,600,379. And High Court asked you pay rupees 20 lakh. And then they
You are not, we are trying to convey you.
Orders will decide the matter on merits. Writ petitions can't be entertained on whims of this court. There is a procedure prescribed under the act which has to be followed
That is true.
absolutely, strictly, without any deviation. So, very well, we'll consider your arguments, pass the order, we'll deal with all these orders also.
On Tuesday, that on that Thursday, let it come, my lord. I will say.
We are deciding it today, sir. Why postpone it to Thursday? For what purpose?
No, purpose
You
is
you
this,
have
my
you have
lord.
shown us the orders. We'll deal with the
I
orders.
have given all these orders, whether the latest status, my lord, at present, because we have given 11 judgments here. What is the
We'll
latest
deal with
status?
each and every judgment order you have cited.
Yes.
We have asked you 4 times, any of these orders, does it consider the import of section 127, please? That the courts are not supposed to entertain writ petitions where a statutory remedy lies. What are you referring?
There is a judgment of the Honorable Division Bench on it.
Must be.
We kindly take it at 2 p.m. my lord. We have also given
that
the
judgment
Supreme
is
Court
also-
judgment is also here.
Yes,
12 to
come out with the Supreme Court judgment, sir. Definitely.
After considering the rival submissions of the parties, we are of the opinion that presently the remedy available to the writ petition appellant is an appeal under 127 of the Electricity Act, where he will have a liberty to place all his points, including whether due process under 126 has been adopted and whether the quantum of assessment is in order.
Yes.
As a statutory remedy of appeal is provided to the writ petitioner, we are in agreement with the
Come
opinion.
at 2 cite whatever Supreme Court judgment you want to cite.
We are on that. We are also on that. 127 will be decided by the appellate forum. But here our prayer is this, appeal as we have filed appeal, let them consider this. We have paid 10,90,000.
10 lakhs, your appeal can't be entertained. You have to pay 50%. That is what the law requires.
My lord, to provide substantial justice,
A litigant,
if even there is no provision of law, court should come. There is also judgment of Supreme Court that
but now we are, fortunately, we have a provision of law, sir.
provision of
Why
law
should
is
we
there,
even think of that situation?
but to provide
A
substantial justice.
litigant who is with impunity indulging in electricity theft, he asks the court to exercise writ jurisdiction to come to his rescue. No, sir, we will not do it.
No.
You cite your judgment at 2 o'clock, we'll consider it.
Deeply obliged, counsel.
You know, you send the final judgments. I know. They've been told that. At 2.
Yes.
Item number 17 of daily list.
Where is the long pending PL? It was filed by certain citizens of Dibrugarh, my lord, Upper Assam Township. My lord, they were actually in a municipal area, my lord, ward number 22 on the bank of river Brahmaputra. And then, my lord, they were agreed by, my lord, garbage dumping by the municipality in
Sir,
the
on
wish.
1st February It has been observed that there is no longer dumping operations
My lord,
not being undertaken.
my instruction from my clients is that after 2020 COVID pandemic, since then, it has been
Shifted.
stopped.
Stop.
Stopped, but we don't know the existing garbages were removed or not. And there was also a proposal for my lord doing certain things scientifically,
Issue of garbage is
whether those has been done or not.
is staring us in the face. You have been. There is an area. The road proceeding to Rajkot. There are huge. They keep on running. Stretch. There has to be proper ways to the in. That's what the advocate general we will take it forward. Therefore, environment will be dealing with it. We'll take this matter up in a suitable bench. We'll pass the order.
My lord,
We are concerned with this issue regarding solid waste disposal.
Yes.
And we plan to take it to some logical conclusion
Yes, my lord.
with the assistance of the government.
My lord,
This
because
is a huge problem across the country.
my lord, within the vicinity of 300 meters, there are schools, there are offices, and there are other things, my lord. And the entire
You see, sir,
water.
as long as the human population is still there and Thanos doesn't act, this solid waste disposal will keep on generating.
My instruction
How
is,
to dispose it off,
No.
that is what we have to devise.
my lord, there was a
and find out.
decision for shifting, my lord. My need.
Shifting is not the ultimate solution. You'll form one more mound of solid waste in another pristine area.
My lord,
So it has to be disposed of.
scientific process of handling.
Yes, so we'll ask the Advocate General to assist us in this case.
Lord.
Put it up in the bench to be constituted for hearing the environment matters.
My instruction is for last 2 years, they have stopped.
Don't worry, sir. Even if they have stopped, we'll continue the
Yes,
petition.
yes.
Item number 19,
And we'll invite all concerned advocates who are interested to assist the court for this issue. Solid waste disposal. We may even involve the IIT people to give their suggestions.
That's a very good idea, Lord.
Yes.
Oblige.
So Singapore is generating virtually major share of its electricity by incinerating solid waste. It is importing solid waste from all over the world. Why can't we do that? There was one experiment in Delhi. Probably it was not successful because they are using obsolete technology.
Even here, my lord, this problem arose, his lordship knows. For a while, my lord, Chandrapur was chosen as the dumping ground. Then in view of popular protests, my lord, again, my lord,
Dumping ground is not the solution.
not the solution,
It has to be instantly disposed of.
not the solution. My lord, energy can be generated.
Yes, precisely.
item number 19,
Yes.
May I please, your lordship, my lord, in this matter, my lord, inadvertently to some delay on my part in taking step. I have today taken step, my lord, for response number 7.
It is submitted by Mr. Kadir that steps on respondent number 7
7.
has been taken today. Accordingly, registry to verify and make necessary endorsements in respect of steps stated to have been undertaken by the appellant on respondent number 7 list after 2 weeks.
Yes, my lord, I have another prayer, my lord, since earlier 2 occasions I have taken step. So I may take that Dusty service, my lord, in addition.
Meanwhile, Dusty is also permitted.
Oblige.
item number 20 to 26,
This is an issue related to environment. So we'll take up In a
before that
dedicated bench,
appropriate bench. My lord.
dedicated bench,
My lord, only
yes.
thing is, my lord, I may point out in item number 21, there was a request made to the principalship conservator of forest to be present for assisting on lordship.
Okay,
Understand, my lord, he is in bereavement. 2-3 days later, he can appear.
we'll do that. We'll grant him time. He may come on the next day.
Huh.
Same order. We place before a bench, dedicated bench for hearing environment related matters.
In fact, my lord, that solid waste thing is very important for us, my lord.
It is important for everyone, sir.
Yes, yes, we'll have to, some device has to be
Anyone
found out.
has been to Ahmedabad, there are huge mountains of solid waste. They are burning round the clock. It is impossible to even stand within a distance of 2 kilometers from that mountain. Unbearable stench.
In fact, my lord, the Guwahati Municipal Corporation did enter into agreement with a particular party with the idea to generate electricity. Somehow that, my lord, did not succeed.
Maybe.
Anyway, my lord,
We can contribute
something has to
something.
be devised, my lord.
Yes,
Otherwise, it's a huge
yes.
problem.
It's a concern for every
Everyone,
human being.
everyone.
Lordships, by mentioning item number 22 to 26 is a different matter relating to violation of Supreme Court's order on illegal mining in the tropical rainforest, where Justice Kotogi's. My lord, my matter is no way connected with 21. On the earlier day, I was not present.
So let it come up, before the bench, which will be dealing with environment related issues.
There is
More or
another
less, we are constituting a particular bench for that.
Obliged.
Item
Yes.
number 30.
Local. No, it will be nice. You may go. In fact,
More time.
In this case, my lord, we have filed the affidavit today, my lord. Let it be taken up along with our affidavit on Friday. Yes, my lord, Friday.
Friday, I want.
Or any other date.
let it come after 13th.
My lord.
At the request of Mr. J. Chutia, Learned Counsel appearing for the Karbi Anglong Autonomous Council, that the matters be listed again on 14th. 14th. Meanwhile, affidavit stated to have been filed by the Karbi Anglong Autonomous Council, be connected to the case records. Mr. B. Borua appears for the petition, PL petitioner. List accordingly.
Item number 31.
No one. We can reassemble at 2. We will meet again at 2. Okay. Yes, please.
With humble apology, my lord, I take the indulgence to mention item 14 and 15 lordship. I have contacted the council for the caveat, my lord. Second is not possible for me, my lord. So my lord, kindly fix on 10th, your lordship.
On 10th.
10th.
Very well. On 10th.
Give love license.
Ladies. Equal complement.
May I please? My lord, the petitioner has taken a term loan of rupees 56 lakh lordship. Due to COVID-19 lordship, he suffered a lot. And my simple prayer is the lordship now, a buyer has come out and he had agreed to take my flat on 1 crore 20 lakh. Just I want some time and the buyer will deposit directly in the bank account.
Sir, why the simple question from the court is, why should we entertain your writ petition? We said so in the morning. Read judgment authorized officer, State Bank, Travancore, Matthew versus Matthew. Why the writ petition is to be entertained? Go to the DRT, make this request. They will consider.
Lordship, that is not equally efficacious remedy.
That is a statutory remedy that is efficacious. All litigants are going there.
No, Lordship.
If it is not efficacious,
Lordship,
challenge the virus thereof.
Lordship, your Lordship will recall that Matthew Bhargave's judgment, where it is clearly mentioned by the apex court that if the borrower is ready to pay, then it should be accepted, Lord.
Sir, all these things are to be taken up by the statutory authority. We are not opening the floodgates of writ petitions.
In similar case, Lordship, in this, many matters have been entertained.
And then why writ petition to division bench, sir?
Lordship. Because it is a SARFAESI action, that's why. That's why, Lordship.
But we are not entertaining writ petitions, sir.
No, my Lordship, I am not challenging any SARFAESI order or anything else. Simple, my prayer is the Lordship, I may be given 10, I'll deposit 10 lakhs Lordship within a week.
You
And
do it.
remaining amount next
You
10
don't
days.
need our orders for that purpose.
Lordship,
Since you are not challenging any order, you may deposit whatever money where you want.
they are
But
not,
we are not. Why should they accept when the orders are not in challenge?
Lordship,
They have to act as per the law.
22nd of instant month, I have preferred a petition and it was relief was granted. Similarly, that I will pay 10 lakhs. And thereafter-
Maybe, sir. Tell us how to bypass the Supreme Court judgment in the case of authorized officer case versus
No,
Matthew.
recent 23 judgment, I am aware of that.
That is 2021 judgment,
Yes,
sir.
recently, same line 23 also. Sir.
Yes.
Arvind-
So tell us, how do we ignore that
No, simply,
law laid down by Supreme Court?
Lordship, I have no, because the auction is fixed today. And
Sir, you are aware that the auction will take place today. How many days back?
Lordship, the
Notice was published when? What is the date of publication of notice?
24th of January.
So now it is more than a month.
No,
Almost.
now, Lordship, I am,
Equitable relief, sir. Supreme Court says no.
Lordship, now I am in a position to pay Lordship. At that
Sorry,
time,
sir.
when I was arranging money, Lordship.
That is true, sir. That DRT is there. You should have approached DRT, requested them to give you,
There-
make that arrangement.
Huge amount to be paid as a court fee Lordship there. That is not
Has to be done,
equally
sir.
efficacious. Lordship, I please to pay.
Then away judgment.
Please.
Find out, give out our judgment. Recent, 3
No,
days.
Your
back.
Lordship, whatever judgment, I know, I am aware of it regarding judgment, 2023 judgment is
We
in
have
the
passed the
same line.
judgment 2 days back, sir. Similar writ petition we have dismissed.
Last page, Your Lordship.
How does it come to single bench then, sir?
There is precedent, Lordship, in this honorable court, many such writ petitions. In
Sir,
the writ
this
petitions.
benevolent kind of litigation, we don't approve.
No, Lordship.
There is a procedure
bank-
prescribed by law
Bank,
that has to be followed.
bank will get the money, Lordship. I'll pay within 10 days, Lord.
Bank will get the money by auctioning your property. That is why the mechanism is provided.
Many banks property position taken by the bank, Lordship, lying without any bidders.
Then you
No
go
bidders.
to
turn up.
the parliament, make a representation, scrap the law. It is not working.
Lord. Please, Lordship, humanitarian ground, it can be considered.
Sir, how the writ petition was entertained by single bench? The law order you are
Because
citing,
I had not challenged any SARFAESI order.
even in this, you are saying you are not challenging.
I had not challenged.
Sir, even here you are saying that you are not challenging any SARFAESI order.
No, I am
You
not.
only want to buy time.
Simply, I have time, only time, Lordship.
Then how does it come to single bench?
No,
Division bench.
SARFAESI order is not challenged,
So
Lordship.
then how does it come to division bench, sir? Read your prayer, please.
In the presence, there is a prayer not to take the position. That's why. So that is arising out of SARFAESI. That's why I filed before your lordship.
Sorry, sir, we are not entertaining. Dismiss in light of availability of statutory remedy. State authorized officer, State Bank of Payment Court. Thank you. Yes, precisely, this is the order.
Item number 49, time being.
May I please, your lordship. My lord,
अपना ही order हो जाएगा.
I have three authorities. Your lordships.
Yes,
Three authorities, your lordship.
let us see, sir.
One is from Honorable Supreme Court and two is from our High Court.
Let us see.
Now, let us see first the Supreme Courts. Actually,
Have you
their
given the
demand,
citation? Have you given the citation, please?
yes, I have given. That is 2012, 2 SCC 108.
Yes, please.
I'll make some time, my lord, because this is the life and death question for me. Since to 1 and 3.
All the time you want, sir.
Yes.
We are here
Now-
till 4:15.
Now, lordship, I am reading the most important para 78 first say. Then I, so this judgment will cover our case.
Hmm.
Para 78.
1-7.
No, only 7, 7, 8,
7.
7, 8.
Yes.
May I read, my lord? Once the order of assessment is finally passed, this order finally passed, and is served upon the consumer, he is expected to pay the said charges unless being aggrieved from such an order, he prefers an appeal under section 127 of the 2003 Act. The appeal under section 127 would lie only against the final order passed under section 126. That too within 30 days of the said order. The appeal shall be filed, maintained and dealt with in accordance with the procedure specified in section 127 of the 2003 Act. A bare reading of the provisions of section 127 shows that it is the final order made
Sir,
under
which
section
para you are reading, please?
para 78.
78.
Yes.
Yes.
Once the order of assessment is finally passed and is served upon the consumer, he is expected to pay the said charges unless being aggrieved. From such an order, he prefers an appeal under section 127 of the 2003 Act. The appeal under section 127 would lie only against the final order passed under section 126, that too within 30 days of the said order. The appeal shall be filed, maintained and dealt with in accordance with the procedures specified in section 127 of the 2003 Act. A bare reading of the provisions of section 127 shows that it is the final order made under section 126, which is appealable under section 127 of the 2003 Act. In other words, issuance of a notice or a provisional order of assessment as may be made by the assessing officer in terms of subsection 1 to subsection 3 of section 126 of the 2003 Act would not be the order against which an appeal lie. So here, in this case, my lord, provisional assessment order was served on us without giving any opportunity of submitting our grievances. Now, till today, within 30 days, final assessment order has to be made. They have not done this. Yep. Let me first, let me satisfy your lordships. Now, within 30 days, they are bound to pass final assessment order.
Let us first ask them whether final order has been passed.
Then other
Just
things
hold
are
on,
also
hold on,
there.
sir. Let us make it clear.
My lords, I have the original record. They will make everything.
Has it been communicated also?
The provisional assessment was communicated. It was acknowledged and received by them. Thereafter, they filed their objections, subsequent to which we finalized and passed the speaking order, my lord, which is the final order.
Whether you have communicated to
It
the
is
party?
communicated, my lord.
No, we have
Whether
not-
it is a part of the pleadings? In the writ
No,
court?
it is not. It is not before this one.
No, but why didn't you mention in the writ court that final order has been passed?
The records were already there before the learned single judge.
Gentlemen, why didn't you state so in
My lord,
affidavit?
we stated so much somehow.
Let us read. Let us read your affidavit.
No affidavit was filed, my lord. In the
This was
matter.
decided
My
without
lord,
waiting for
based
it.
on the records, my lord.
So all right, you file an affidavit. Bring this fact on record. We'll take up the matter thereafter.
My lord may just see the final order, my lord.
We
They
assume that
served
it is
upon-
passed. The other side must know.
My lord. They received a copy of the final order also, my lord.
They have,
Yes, my lord.
and that was not challenged,
That was not.
even in the writ court.
No, my lord. There was a earlier writ petition wherein they challenged the final assessment. Based on the judgment, my lord, the copies of which I shared earlier, my lord, on the honorable division bench.
They have challenged the final assessment by
They
the
challenged
earlier writ.
Earlier writ, and they took liberty to approach the appellate authority under 127.
Oh,
Thereafter, this second writ petition came into being. My lord.
right.
My lords, if I may just point.
Flag number,
My lords, flag number A is the inspection report. My lords may not deal with that.
which is the
Flag,
final assessment.
my lords, that is flag number D.
D.
D, my lords. It's a speaking order dated 5th January 2022, my lords.
Yes.
It was received by them,
You say that it was challenged by them in writ petition.
my lords. The earlier writ petition, my lords, the order also is here, my lords.
How this judgment helps you, sir? Final assessment order is in your knowledge. You challenged it. It's a fact.
My lords, the earlier writ petition, the order, if I may,
Yes, please.
if I may show that, my lords.
Yes.
The order starts at page 110 of the writ appeal, my lords. The earlier writ petition.
Yes.
Now, the relevant portion starts at para 9 at page 115. After hearing the parties and upon broad consensus arrived at the bar, the instant writ petition is disposed, giving liberty to the petitioners to prefer an appeal before the appellate authority under 127.
Right.
Such appeal may be preferred within a period of 7 days. And if the appeal is filed, the same be taken on board and disposed of within a period of 30 days from the date of receipt of a certified copy of this order.
Yes.
Then you have filed appeal.
That
is
Right.
They
So
filed
get
the
that
appeal.
adjudicated.
My lord,
Get the appeal adjudicated.
that is, my lord, my limited prayer was here. There are so many illegalities committed by them. They have
Sir,
totally
the appellate
violated.
forum is seized of jurisdiction to decide all matters of illegalities.
Definitely, we have filed appeal. We want disposal of the appeal,
Okay.
but thing is this, my lord. My lord,
So he has
thing
to
is
do
this,
that.
in every cases, this honorable High Court provided interim relief. We have provided.
So all right, sir, we are not doing so. Challenge our order to the Supreme Court.
No, my lord, every person cannot go Supreme
You
Court.
just can't
Your
threaten us
lordship is
that
here.
this court has provided relief. So you are bound by that. If relief has been provided, it has been provided contrary to provisions of law. We are not bound by those single bench orders. Sorry.
No, Supreme Court is also saying, my lord.
Supreme Court says that if there is a final order, you have to challenge it by filing an appeal. That is what the law of land is.
That we have challenged, but they are saying that pay 50%.
Yes, it has, that
So
is the
that is the
requirement of
problem.
law. That is the requirement. What's wrong in that demand? That is what the law says.
Law says this, my lord. Every time law would not fulfill the demands of justice. Sometimes, my lord, because we have paid substantial amounts.
Sir, we are bound by the constitution and the laws. We have taken the oath to affirm that.
But my
So,
lord, in many
if the law
cases,
says,
your lordship is a court of record.
yes,
Lordship may interpret the law in a manner to provide substantial justice.
to
So
a
here-
person indulged in electricity theft.
No. Yeah, theft does not lie. Is here, my lord, this judgment, Supreme Court said that theft would not lie. Theft is another thing. Because it is coming in my bill. If it does not come in my bill, then that will be theft. There are vast difference theft and unauthorized use of electricity. Even then,
That is a mode provided to the consumer to escape prosecution. That all right, you pay the charges and then at least you will not face prosecution. That is how the mechanism works.
kindly consider we are now financially pauper. This is the situation since 2019.
Go for IBC. Their demands will be
Some,
wiped off there.
some relief, my lord, to the party, considering that we have paid nearly 11 lakhs already.
Sorry, sir.
And some installment we will pay. My
Not a
lord,
bargaining shop here.
my lord, one thing, my lord.
Yes.
Understand. We have paid 10,90,400. So
Pay the remaining 30 lakhs and file the appeal.
30 lakhs, my lord, that is by submission, by installment, some installment, there are so many other installment, we will pay, let them dispose the appeal.
Is it provided for in the mechanism of appeal, sir?
No, my lord, in
Make
so
the
many
pre-deposit.
orders, installments have been granted. Because our industry is closed, my lord, this is the bread and butter of so many families.
That
So
is
by, we have paid nearly 11 lakhs, the rest of the 50% they are saying, of course, we will pay, but that should be installments and the timetable may be given to them to dispose.
What do you say, Mr. Counsel?
Consider, my
At
lord.
least you will get that money.
Very well, my lord. My lord. Not to be treated as a precedent, my lord. My lord. An observation to that
Obviously,
effect,
we'll make it clear.
my lord.
So you will make payment of the remaining pre-deposit in what time?
Within 6 months we will
Ah,
pay.
Sorry, if you do it in 2 months, well and good. Otherwise, the law will take its own course. We can grant you 2 months' time. That's all.
2 months, because our financial, we are very poor now.
So very well, sir.
Let it be my lord, 3 months.
Delhi is not far away.
Let it be my 3 months, my lord.
No, sir. 2 months means 2 months.
As I leave you to lordship.
Writ appeal number so and so. This intra-court writ appeal is directed against the judgment and final order dated so and so, passed by the single bench, whereby, the writ petition referred by the petitioners with the prayer in the following terms was dismissed. At the outset, then counsel for the respondents has raised preliminary objection regarding maintainability of these proceedings, urging that statutory remedy of appeal under section 127 of the Electricity Act is available to the appellants. For that purpose, they would be required to make pre-deposit in terms of the statute, and unless and until the pre-dep amount is deposited for filing the appeal, the same cannot be entertained. Then counsel for the appellant submitted that as the industry is closed for the last more than 1.5 years, the appellants are not for the present, able in a position to make outright payment of the pre-deposit required, mandatorily required for filing of the entertainment of the appeal. However, if the payment of pre-deposit is permitted in installments spread over a period of 3 months, the appellants would be able to abide by the requirement of law, and thereby, they would be successful in pleading their cause before the appellate forum. Learned counsel for the respondent has opposed this submission, urging that if any direction in this nature is given, it would form an incorrect precedent. First up, in view of the peculiar facts and circumstances of the case, and considering the fact that the appellant industry, the industry of which the appellants are constituents, is closed for the last more than 2 years.
1 and 3 years.
1 years,
1 year, 3 months.
1 year, 3 months, by way of an exception, we grant 3 months time to the petitioners to deposit, to make the mandatory pre-deposit for filing of the appeal, for entertainment of the appeal under section 127 of the Electricity Act. If the remaining amount of pre-deposit is paid on or before May 2023, the appeal preferred by the appellants shall be considered and decided as per law.
My lord, one prayer well, that we will abide by that. But thing is this, my lord, again, 3 months should, if we pay the first installment as per your lordship desire, then they may dispose of the appeal. And we will pay we have given assurance. Because otherwise, after 3 months, we will lose further. We will lose further.
So then we will decide your appeal on merits. If you are continuously haggling on these issues, because otherwise your appeal has become time bound. Make the payment, you make the payment in one go, get your appeal entertained. It is the outer limit of 3 months. It's up to you to make the arrangement of the money and get your appeal decided. Equities are not available for persons who flout the law in this manner. Okay,
I'm deeply afraid.
Item number 31.
the appeal is disposed of in these terms.
May it please your lordship, kindly adjourn the matter for today.
You want an adjournment?
Yes, lordship.
The request of learned counsel for the,
I may not. Actually, nothing remains in this matter, Lord. Already preliminary inquiry has been initiated, Lord. And that a year back, Lord.
What is the prayer in the writ petition?
it was at the stage of seeking grant of sanction or approval.
Lordship.
Initially, it was pending for approval. Now
Yes,
approval has
sir.
been
Now
granted.
approval has been granted, Lordship, and it has already been.
Give her a copy.
Lordship, I shall.
Copy is there, long back.
Yes, Lordship, I
Already placed on record.
submitted. Yes, Lordship. But they were taking adjournment after adjournment, Lordship.
What is the point, madam?
No, I'm appearing on behalf of AR Bhuya. He's on legs, actually.
Call him, we'll pass it over. Inquiry is already initiated. Why keep the petition pending, please? Pass on.
Item number 34.
These are those. We have kept some matters on 27th. This is from.
My lord, in this case, already the honorable court has granted status quo in IA, my lord,
Yes.
on 25th of January, my lord. Let the matter be fixed for admission, my lord.
Not admitted.
Not yet admitted.
This is against the decree of divorce.
Yes, my lord.
So why do we need a stay? Section 15 is there. Why is there need of passing a stay order?
My lord, against the judgment, my lord, as it is, as the appellant's prayer is, my lord, rejected, my lord, in the family court, my lord.
Not entitled to decree of divorce. This is a rejection of the divorce application.
My lord, and
Why is there a stay required on such judgment? What is the effect of that?
my lord, she was directed to resume, my lord, restore.
Okay, section 9 was allowed.
Yes, my lord.
All right.
Learned counsels, MS so for the appeals for the appellant and Mr. Sharma for the respondent, sole respondent.
Sorry.
Let the
Have
matter
you
be.
filed appeal against rejection of the divorce application? No.
We admit this appeal, matter be listed for hearing. Interim order passed
On 25th
On-
of January.
so and so date shall continue till disposal of the appeal.
Both the divorce are filed by
Right.
restitution.
Obligement.
Item number 35.
May I please, in this case, one IA is filed on 23, Lordship. Kindly the matter will come up with the IA.
What is the prayer in the ISR?
Lordship, stay of the operation of the interim order dated 72/21.
Right.
When did you file it?
Pardon, Lordship?
You filed the IA.
Yes, Lordship, on 23,
It is submitted by Mr. So-and-so learned counsel to the appellant that an IA has been filed praying for interim orders, which however is not listed before the court today. Accordingly, let the matter be listed after a week.
Okay.
The registry is directed to connect the IA stated to have been filed along with the matter bill. List accordingly.
highly obliged.
Item number 37.
Wait, please, Lord. But this is an appeal preferred with the state, my lord. There are other similar connected matters, my lord, which are fixed on 28/3, my lord.
28 March.
28 March, my lord.
These are
Regarding grace mark, my lord.
grace marks.
Yes, my lord.
This is by the state.
This is by the state, my lord.
Scaling.
The cross appeals. Submitted by learned counsel for the appellant, Mr. So-and-so. List these matters with other connected appeals being writ appeal number.
W number 333/2022 and 283/2022.
Double triple three.
222, my lord.
222 of 2022 and
And
other
two-
connected matters.
Yes,
It is submitted that the matters are fixed again on
28/3.
28th of March. Learned counsels, Mr. Chaudhary and Mr. Pothakur are representing respondents,
Private response.
private respondents. List accordingly.
Obliged, lordship.
Item number 38.
May I please, your lordship? We have taken steps through paper publication and we will submit the copy tomorrow.
There are more than one respondents.
We have five
Yeah,
respondents.
5 respondents are there.
I've been implemented as respondent number one.
One.
Lordship, since a substantial amount of my hard-earned money is involved, I humbly pray that the matter may be listed for admission at an early date.
Once the service is complete.
You have to file an affidavit. You're filing an affidavit.
Tomorrow I will find it.
Learned counsel, Mr. Parvez, appearing for the appellant, submits that steps by paper publication as directed by this court has been taken and an affidavit to that effect is required to be filed. He prays for a week's time. List this matter after a week. Mr. P. Bhaumik, learned counsel, appears in person.
Item number 39 and 40.
May it please the lordship, my lord, the learned advocate general will appear in this matter, my lord. He's on legs in another court. I pray that the matter may be passed over for the time.
What is the issue involved, please?
My lord, release of salary of the petitioner, my lord.
Well,
An appeal
we
has been
are
filed.
working in an organization. Now a inquiry has been held and they say that our appointment is illegal. But the learned single judge has said that since we had worked for the period, so salary has to be paid. Basically they have relied on two judgments of the Supreme Court to say that since our very entry is illegal, that's why we are not entitled to salary. But the learned single judge has distinguished those two judgments and passed a reason order. So my lord, they are saying it for pass over for the time being, subject to your lordship's convenience. May I pray that this matter may be taken up on 3rd, my lord. I am also in a legs in I have one matter.
Third will not be possible. You can have it up any day after 13th.
Yes, my lord. Yes.
So may I pray one, Lordship, one thing, in this appeal, there is not what the appeal is admitted in that,
No, there are other respondent services awaited.
Lordship, then also, Lordship, notice is being.
Decided 15th.
Have you taken steps on the
Lordship, I've
respondent?
already taken steps and all the he
No, no,
was the
no,
caveat, Lordship.
Caveat nahi.
Only appeal to be admitted, Lordship.
Caveat is not for all.
He is in opposition to the admission of the appeal.
Lordship. Lordship, all are,
It's an appeal as of right.
no,
It's an
Lordship, here in this case,
intercourt
all these
Point
employees were,
point out the illegality in the order.
Lordship, all these employees. Lordship,
We'll see, we'll see.
Lordship,
And the request of the councils at the bar listed on 14,
15, my lord.
15. 15 over.
Lordship.
My lord, 16, my lord.
16.
16. I'm sorry,
16.
16. Deeply
List on
obliged.
16.
Highly obliged.
Item number 41 to 44.
May I please, Lordship? Lordship, kindly pass over matter for timing. matter.
44, I'm appearing, my lord.
Yes.
It is a fishery matter. Where there are a number of cases which were decided by learned single judge. And this writ petition was dismissed. The appeal was preferred against the order. So my learned friend, he is appearing item number 41. There was some interim order. Item number 44, similarly, we also filed. But by that time, when the writ petition was dismissed, my lord, settlement order was passed to the party concerned. So we have thought that implement application, we made them a party. So implement application was filed, but it is not on record, my junior, I checked. Implement application along with an IA for stay. So I think let it come on record, my lord. My implement application, my lord.
You filed a writ petition,
With item of 44, mine is 44.
44,
Your lordship is looking item of 41.
41.
Yes,
Who-
44
Who's who's for 41?
41, my learned friend, I think is led by Mr. M.K. Chaudhary.
For 41, 40.
It's almost
You
similar.
challenge the virus of,
Lordship, we have filed an IA matter for allowing the applicant for to continue the run procedure on daily basis. matter.
That will frustrate that will,
no, but why a writ petition before a division bench?
because single judge has passed an order in favor of the FDC, Lordship.
We are writ appeal. Mine is writ appeal.
No, 41 is a writ
14 is
petition.
a writ petition.
Writ petition.
41, no, Lordship, this writ petition was passed later on, Lordship, after passing of that order. It was similar. This was in line with this. Actually, in this fishery, Lordship,
Question which my brother is posing
Lordship,
is that why a writ petition before division bench?
Lordship, it was being posted by the learned single judge because in this case, similar issues were said.
Is an order by honorable single judge that should be placed before division bench.
Yes, Lordship.
Along with the identical matter.
Lordship.
Which is that order? 1912.
Lordship, in our IA matter,
Yes.
423 of 2023. Page number 12 to 15, my lord.
1912.
Yes. Lordship, all those fisheries were settled without any advertisement, nothing, Lordship.
So when do you want, your application is yet to be tagged?
Yes, I think I is not before this court.
It is submitted by Mr. D. Das, Learned Senior Counsel, assisted by Mr. So-and-so that an IA has been filed for implement, which however has not been listed in writ appeal number 366 of 2022. The registry is directed to trace out the IA and connect it to the writ appeal and list it next day.
3457. What is it? then? Nisar Ahmed. So there is an IA listed. Something else or what?
Fee of the order, initially this was.
There is limitation part of
Where?
it. Another writ appeal is there in a similar and 56 of 2020. That
You
may
want that also to be tagged here?
Yes, Lordship.
File of so and so may shall also be tagged with this bunch of matters and listed together. Okay.
Right from 41. When do you want the matters?
Lordship, a bit earlier 15, Lordship, because in 2 matters there is stay, Lordship. Not to finalize the tender process.
16. 16th March.
Highly obliged, Lordship.
Item number 45.
Lordship, I have a difficult submission to make because this is a review filed by the state. When the PIL was heard the last time, Your Lordship, a statement was made by the council representing the department that we had taken a policy decision not to issue mineral concession settlements in that area. That statement was made without instructions, Your Lordship. So there is an error which is crept into judgment. It was on the basis of that statement that the PIL was disposed of.
Now you're changing stands.
No, because no such policy decision was taken, Your Lordship.
It was a wrong intimation
It was
given by the council.
A wrong statement was made, Your Lordship, without instruction.
In the PIL,
In the PIL.
in which the review is sought for.
Yes, Your Lordship.
So you'll have to bring it on by way of some affidavit to say that this was, he was not authorized to make a statement.
In fact, we have filed a certificate with this, Your Lordship. Otherwise, if Your Lordship directs, we'll file an affidavit that this.
You have to file an
Very
affidavit
well.
that the council was not authorized to make this statement.
Yes, it was without instructions, Your Lord. We'll make that, we'll file that affidavit.
Hmm.
Our most qualification printed.
ठीक है, ठीक।
The order may be recorded. And we will revise and give it.
No, besides this,
Lordship.
how are you otherwise affected?
Because, Your Lordship, the PIL, Your Lordship, initially on that day, we had raised the objection as to the maintainability of the PIL on the ground that the petitioner had an interest in the subject matter. That issue was decided against us. But because the statement was.
No,
made
no,
by-
no. What we want to know is you are
Yes.
filing the review because of this statement of the council recorded.
Yes, Your Lordship.
Only to that extent.
Because on the basis of that statement, the PIL was closed, Your Lordship.
Hmm.
But do you plan to initiate mining operations?
Perhaps, yes, Your Lordship.
What
That's,
is the material to support this?
because no such steps have yet been taken because of this statement, Your Lordship. Because the statement was made before this honorable court that we are not going to do it. We have not yet initiated the process. But there was no such decision.
Is there any discussion at the level of the concerned authorities that yes, mining operations are required to be taken in that area?
Then I'll ask the concerned officer, yes.
You have
Yes,
to bring certain material on the court.
Yes, Your Lord.
Otherwise, okay, we are happy if mining operations are not taken in sensitive areas.
But that statement was made. I understand what is falling from Your Lordship. I'll.
So you file an additional affidavit.
Very well, Your Lord. Very well.
Better particular.
Mr. KP Pathak, learned counsel appearing for the review petitioner. Praise for and is granted 2 weeks time to bring on record an additional affidavit in support of his contentions made in the review petition. Prayer is allowed. List on so and so date. We issue notice or- We are issuing notice also.
Very well.
Issue notice returnable 3 weeks. The review petitioner will take steps only on one respondent.
Only on one response, 2 or 3, Your Lordship.
Will take steps on the respondents by registered post.
The other 2, Your Lordship, they are state authorities. I mean, from the central government, I can serve copies on the standing council also.
Dusty also permitted.
Very well, Your Lordship. Obliged, Your Lordship.
Item number 46.
This matter has come up for the first time. There is a delay, application for condonation of delay. There's a delay of 20 days.
If no objection, we can conclude.
Otherwise, normally 20 days.
I am for the private party.
I am for the Numaligarh refinery. Everyone is represented.
So there's no objection.
20 days.
20 days.
We leave it to your lordship. Your lordship may condone and fix it for admission in that case.
Heard Mr. Rai Chaudhary, learned senior counsel, assisted by Mr. Agarwal, appearing for the applicant. This is an I for the applicants. The application is filed seeking a condemnation of a delay of 20 days that had occurred in filing the connected writ appeal. Mr. N. Deka appears for
Respondent number 3, my lord.
respondent number 3, Mr. D. Dats, senior counsel, assisted by Mr. Deepak, appearing for
Respondent number 6.
respondent number 6. And the union,
Union we have served.
Mr. R.K. Dev Chaudhary appears for respondent number 5.
No, 1 and 2. Union of India is 1 and 2. 1 and 2. 1 and 2.
1, 2, and 5.
1, 2 and 5.
1, 2, and 5. This application has been filed for seeking condemnation of delay of 20 days. Heard learned counsels, perused the grounds urged. Since there is no objection from the respondents opposing the delay, on the grounds urged, it is seen that sufficient explanation is there for the condonation of prayer for condonation of delay. Accordingly, I is allowed, delay of 20 days is condoned. The registry is directed to register the writ appeal and list it after a week. I disposed of.
But may I have the indulgence of praying for a fixed date, if it is not inconvenient to my friends?
You first the appeal will have to be numbered. Then
That is true. That is true.
then you can fix a date. After it is numbered and listed, you can fix a date. Or you can approach the registry and make a request.
Obliged. Item number 50 of supplementary list for orders.
Meet legal.
Direction was there, fixed date, which was 27th, I think.
Yes.
Look, this is with regard to extreme delay in Milot finishing the construction of a road connecting Milot Silchar, Harangajao and Haflong section. Lord, the contract was awarded in the year 2006, Milord. Thereafter, 3 contractors, Milord, contract work was terminated. And
This is
Yes.
Lord, the contract was awarded.
Do we have a statement from NHI?
Yes, my lord, I have filed a affidavit. Thereafter, it was listed on 15th of this month, my lord.
Yes.
And honorable division
That
bench has
day
asked
we are directed to find the affidavit.
I have filed additional affidavit. In regard this one, we have point was there at what time it will be completed. As per agreement, it was a three years, my lord.
Yeah, right.
And I have stated also reasons why 3 years required in additional affidavit, my lord. That is,
But now what is the outer limit you want? us
no,
to-
that is a 3 years as I have discussed with the office concerned officers, my lord. This is the 3 years will be required. I have mentioned also in my additional affidavit. I have also asked that can it to be circumcised to less than 3 years. So this will be required because
When did that period of 3 years run out?
that is from this month of January of 2000 this year.
January this year.
January to September.
And How much more time do you need?
20 by 26, it will be completed.
26.
Ah.
You are doubling the time.
No, doubling means this agreement was signed in December itself for regarding this particular before coming.
December of which year?
To 2022, my lord.
For a period of 3 years.
3 years, because I have mentioned also reason for why 3 years required. Because already agreement was signed between them.
What was the original time of contract? When was it supposed to be completed?
That was long back, my lord.
8 months. Then how do you say that it was
In
the guy
2007.
is
No.
operating till 26?
But that is why now this fresh contractor we have given, now to this
Original contractor.
already
what happened?
contractors, as it 3 contractors, we have terminated them, my lord. Now on new, we have given to new contractor. Because the lordship, I have given everything in my additional affidavit, my lord. Here, I have stated also, paragraph 5. Paragraph 5, my lord. Lordship may peruse my additional affidavit for timing, page 13, my lord. Lordship got it. Additional affidavit.
Yes, we have it.
May I read, my lord?
Yes.
It is to be stated that herein that finally agreement was signed between National Highway Authority of India and Messrs. Dinesh Chandra Ten's Indian Highways Private Limited for construction of road in question within a period of 10995 days. An operational period is 15 years commencing from COD, that is completion of operation date. Project is declared as 1633. The appointed date of the project is declared as 16/1/2023, and period for completion of the road in question is 3 years because of the following points. The stress is known to receive heavy rains during the monsoon season. Also,
Well, you started construction 15 years back.
that's correct, my lord. That is why
Are we
earlier,
living in the medieval age?
my lord, that is why earlier.
Was it is rocket science that you can't construct roads?
Because, my lord, earlier contractors who had not taken into consideration that I have mentioned in my paragraph, then we have what action we have taken to them. Earlier contractors we have foreclosed and terminated. Ultimately, this is a come, my lord.
Going on.
You keep your project director available in the court.
My lord,
Keep your project director available in the court on the next date.
my lord,
We'll ask him.
my lord.
Milord, I feel, Milord, there is some serious flaw with the DPR, Milord. Blame cannot be shifted to the 3 contractors. They could not complete. That means there is some serious flaw with your
provided the
DPR.
design? Who is responsible for the designing part?
That designing DPR was done initially by NSA only, initially. That construction was given to first contractor, he could not complete. That is why you have taken into tax. Then second also, third also have taken, they have not, could not. That is why ultimately we have signed this one.
You keep your project director available here.
Oh.
We'll talk to him. And counsel for the NHI shall keep the project director concerned present in the court on the next date of hearing. List on 14th March.
My lord, may I pray 13, 14, 15 for exclusively out of station for
16th March.
my lord.
You're not available
No, I'll be not available. I will be going to rowing.
till,
For 13, 14, 15, I'll be not available because I have to go outside.
all right. It's on 16th.
16th of March, my lord.
Number 51.
Keep your place.
Like.
May be lordship, my
This one?
lord, this is review, but not the review of the judgment, my lord. I just, my lord, some point we have raised, that was not, my lord, actually, no finding on that point. This is the only, I take your lordship to page 20.
According to you, you are entitled to the regular that
No.
ROP.
Revised scale,
Revised scale.
gratuity and lip salary, that much, my lord. All right, our prayer was for regularization, that was rejected, we are not on that, my lord. Only question, my lord, the 30, 35 years, already they are serving, one already retired, number 1. After about 35 years of service, my lord. And this is the pendency of the writ petition, and others are already in service, my lord, about 26 years to 35 years already they are there. So my only prayer is, my lord, the revised scale of pay, which they are entitled to get since 16, my lord. That nothing has been discussed, my lord, as well as the lip salary. And
Where is your writ petition here?
yes, writ petition, I'm not, and it is not there, my lord.
It is not annexed.
It is not, but it is on the record, my lord, because I just take your lordship to page 17, my lord. The grounds we have taken the writ appeal, page 17, your worship.
From page 14.
Grounds started from my lord, page 14, but I take to relevant portion, my lord. It starts from page 14, my lord. Grounds we have quoted here, my lord. All the grounds we have taken before the writ appeal, my lord. Now 17, your lord, and the paragraph 6.7. For that, the learned counsel for the appeal and submitted before the learned single judge that they accrued right to get revised scale of pay as per ROP 2017. But the authority is paying the old scale of pay as per ROP 10. Learned counsel for the petitioner also submitted that if for any reason the service are not regularized, they may be paid revised scale of pay, the gratuity and leave salary.
The single bench field considered.
So this is the
Why
one
do
that,
you want a review of division bench order?
my lord,
Your
my,
prayer is single
my
bench field
lord,
considered.
he was part, he has written the order. He was there.
My
I
lord was a part of the division bench,
Yes.
but your prayer is for review of the single bench order.
No.
Read 6.7.
No, 3 points, I said that before this honorable division bench, I raised this point.
So read your,
Before the division bench,
read 6.7, please.
yes. For that, the learner single, my lord, this was, your lordship, kind of page 14, my lord, page 14, it will make clear now. Page 14.
Yes.
This your lordship, paragraph 12. Being agreed by the judgment of the single judge, the petitioner preferred the instant writ appeal on the following grounds. So these grounds were taken before the division bench, not before this. Now I come to before page, your lordship will find paragraph 14, my lord. Page 20, my lord. Now our grant is page 22, present, my lord. That was raised before the division bench. Page 20.
We'll have to see that. So we'll have to call for the file of the writ petition first, or the writ appeal file.
Writ appeal, I think
Writ
the
appeal.
next first writ appeal.
No, the writ appeal will contain the writ petition also.
Yes.
All the annexes will be there for the
Yeah. I don't think in the writ petition you made a prayer for payment of.
No, that was for regularization of service.
It is a regularization.
Service along with the area salary, etc.
Salary.
Yes.
But where is the prayer for revised pay?
My lord, we made a specific categorical grounds was given in the before the division bench. We have taken the ground that we made a submission that finding was not there.
No, but that's a new ground. You did not urge before the learned single judge.
Yes, we have stated on oath we have taken by the page 14.
Sir, that was not the pleading before single bench.
No, my lord, pleadings were there, your lordship can see, on the single bench, I'm not having copy right now, my lord.
Make any such averment in your writ petition.
Yeah.
Whether you are entitled.
My entitlement to all pensionary benefits, my lord, because regularization, my prayer was for regularization. And all the pensionary benefits, all the retirement benefits I am entitled.
You verify from your pleadings in the writ petition.
That I will see.
And you submit before the court.
That I will see.
Meanwhile,
but my prayer was only for retirement benefits, but they are getting regular scale of pay, they are paying the contributory.
No, your prayer was
for
giving you regularization.
Yes.
That was your prayer.
Regularization along with all the benefits minus retirement. That's what I think minus that is there.
And to pay
by scale, I am
monthly salaries, area salaries.
So that is area, that is there by scale.
Yeah, it's what is the state, stand of the state?
Well, at this stage, well, I am opposing the review petition because by filing this review petition, the petitioner wants to rehearing of.
No,
Not
that,
necessarily. He asked
that-
for
that-
relief for regularization.
Yeah.
That was not granted.
Yes.
But he
Whether
said
is
that
it-
ancillary relief, financial at least, they
Ancillary,
should be given to him.
ancillary relief has been already been granted by the Lanet Single Judge that has been given, my lord.
no, he wants benefit of the revised
The
scheme.
revised pay was not his case in the writ petition, my lord. It was not, it was not.
So whatever pay scale he was getting, in that pay scale, if there is a revision, then
Yes.
he is not entitled to benefit.
Automatically.
Apart from keeping apart the fact that regularization is not done. But supposing he is drawing the minimum of pay scale,
Lordship.
but with the revision, that revision has benefit has to be given to him.
Well,
You file an affidavit on that aspect.
but that, my lord, I'll have.
You'll just respond to the government's grant of the review petition.
Lordship.
By an affidavit.
Mr. T. Nath, heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Mr. F.U. Borguya for the review petition. Mr. D. Nath, learned senior government advocate, and Mr. Thor for
1 and 5,
respondents 1 and 5.
3 and 4.
Mr. Nath for respondent 3 and 5, 3 and 4. It is submitted by Mr. Nath that he'd like to obtain instructions and file necessary affidavit if required in respect of the claim of the review petitioner that they are not been given the revised pay scale. And which is the ground for on which the review of the division bench order has been sought for. List this matter after 2 weeks,
Lordship may give us 3 weeks time.
3 weeks. List accordingly after 3 weeks.
The number 52.
Please, Lordship. Lordship, due apology, Lordship. Mr. H. Gupta had to leave, Lordship, because his daughter fell sick and he suddenly had to leave for. In any case, Lordship, there is an IA for delay condemnation, Lordship. And
Notice
may be
issued.
Notice may be issued, Lordship. IA 452/2023. Delay of 143 days, Lordship.
Heard Mr. D. Das, learned counsel for DJ. DJ Das appear for the applicant. This is an application seeking condonation of how many days?
143 days, Lord.
143 days, which had occurred in filing the connected appeal. Let notice be issued, returnable 4 weeks. Steps on respondents. Anyone appearing for the respondents?
There is a sole respondent. It's a private respondent.
Steps on the respondents within 1 week from today by registered post. Dusty also permitted.
Much of this.
List accordingly.
Much of this.
Matter number 53.
This is application for corners of delay of 8 days, my lord. Trying that. Government is there, my lord.
Any objection? No objection. Heard Mr. G. N. Sahiwala, learned senior counsel appearing for the applicant, assisted by Mr.
S2D.
S2D, MS S2D. MS so-and-so appears for the respondent. Health Department. The application has been filed seeking a condonation of delay of 8 days. Full stop. Learned counsel for the respondent does not object to the prayer for condonation of delay. Para, having heard the counsels for the parties and perusal of the grounds urged in support of condonation of delay, we find that sufficient explanation has been furnished by the applicant in support of its prayer for condonation of delay. Full stop. Accordingly, we find the explanation. We find that the delay has been sufficiently explained, and accordingly, this IA is allowed. Delay of condonation of 6 days. Delay of 6 days is condoned. The registry is directed to list the connected appeal.
My lord, may I pray, my lord? Maybe listed.
Section of the interim stay
My lord.
Request the single bench to decide your writ petition.
My lord,
This, the debarment was of 14/7, almost 7 months have passed. Request the learned single bench to decide
my only
the writ
thing,
finally.
the only thing, my lord, it is now four
If we
tenders.
accept your stay application, that is virtually allowing your writ petition finally.
My lord, if there are
Honorable
four,
Supreme Court says it time again, stay order should not be of such nature, which tantamounts to accepting the writ petition.
but my lord, as per the Supreme Court judgments, my lord, whether this so-called notice has been issued, my lord. Only I shall submit. And my lord, on the 6, 7, 9, there are four tenders, my lord. So I pray, my lord, second or third, it may be fixed, my lord. Second or third, my lord.
List this appeal. Registry to number this appeal and list it on 3rd. Second March as prayed for.
Item number 54.
Yes, Your Lordship. There's a delay of 7 days in preparing the appeal. On the official respondents, if they have no objection, maybe.
Only 7 days.
Seven. Connected appeal.
Do you have an objection?
No. 54, my lord.
Either you object.
What's the problem if you record your concession here? 12 days delay, someday you will be standing on this side, making the same prayer.
7 days.
Heard MSD Burgoyne, learned counsel for the applicant and learned so and so appearing for respondents,
All respondent, man.
all the respondents. So this IA is filed seeking condonation of 6 days.
7 days.
54. 54 is 7 days while filing the connected writ appeal. The grounds urged in support of condonation of delay has been perused. Learned submissions of the learned counsels have been heard. It is seen that the delay has been sufficiently explained. In the absence of any specific objections from the respondents, this court considered it is appropriate to condone the delay as prayed for. Accordingly, delay of 7 days in IA 461 of 2023 is condoned. IA allowed. Registry is directed to register the connected appeal and list it before the court after
Lordship.
1 week.
There is a connected writ appeal number 44. of
No, let it
23.
be numbered and then listed, and then you can make the prayer, because unless the appeal is numbered, where do we pass the order?
Lordship, yes, I'm sorry.
Insofar as item 55, delay of 12 days condoned. After a week.
The number 47 of daily list for hearing.
May it please your Lord. This writ appeal was restored to the file pursuant to the order passed in the review petitions.
On last occasion, Lordship, notice upon the private respondent was issued.
Issued, Lordship,
Hmm.
and I have taken steps. Services complete.
Has anyone appeared?
Is there supposed to be an office report?
Ordinarily,
There is to be an office report.
yeah.
AD card has not been received. There is an office report, Lord.
This month and date. This is just registered AD. Office report. What is it? This is restored. But neither AD card nor unserved notice has been received till date 23rd February.
Can you not take Dusty? Can you not take Dusty? Dusty service?
I'll try that.
So you take Dusty?
This
Maybe.
service is not complete.
Uh,
The office report says service is not complete. Yet service effected.
As per
The
office,
student is working as
Yes.
Anganwadi worker.
Yes.
So you get them served. You get her served. She's under your employment.
Lordship. Okay, Lordship.
learned counsel will furnish a copy,
Yes.
extra copy.
Yes, Lordship. I'll do.
Office report dated 23/2/2023 reflects that service on respondent 5 is not complete. Learned counsel for the appellant submits that all those steps have been taken. Steps have been taken as per the direction of this court. Since the private respondent is in employment, we permit the steps to be effected through the office of director.
Lordship through the office of the director, Lord.
Director, Social Welfare, respondent number 2. The learned counsel for the appellant will furnish sufficient copies of the writ appeal along with all enclosures and serve it on the Director, Social Welfare, who will cause service to the private respondent number 5, namely so and so, so and so. An affidavit to that effect should be filed before this court.
Lordship.
List after 3 weeks.
Lordship.
Item number 56 of supplementary.
May it please the Lordship. My Lord, in this writ petition, we have challenged the virus of a particular rules, my lord, regarding recruitment of to the junior grade of the Mizoram Police Service. My lord, the feather cadre for promotion to the grade of, my lord, Mizoram Police Service junior grade is the, my lord, Inspector of Police, be it armed branch or unarmed branch. Now, my lord, and the qualifying service required is 5 years. So as long as an inspector, whether he's in armed branch or in unarmed branch, then he is eligible to be considered. So that is the, my lord, main rule 6. Now, my lord, the proviso has not to speak of, my lord, it has rather restricted the scope of 6, my lord. So basically that is the challenge. Now, my lord, there is a letter by the Director General of Police, which was written to the, my lord, government way back in 16. It's a matter of 2017, my lord. If your lordship would kindly come to page 86, where, my lord, the Director General of Police himself has, my lord, pointed out.
Yes.
Now, my lord, it's a long letter, but I'll have your lordship's kind attention to page 87. The first subparagraph. Increase of the quota of armed branch by pulling the same from the existing sanctioned strength was found not feasible as their counterpart UB personnel had already occupied the post. The best solution to increase quota of armed branch without hampering the quota presently occupied by unarmed cadre is by creating 4 new posts, 3 posts in MEP battalion and 1 post in PTS, by of surrendering a tiny percentage of numerous unfilled vacancies lying in the battalion at present. This was agreed by the representatives of all the association welfare committee present in the meeting. So, my lord, having considered this aspect of the matter, my lord, this honorable court, if your lordship will kindly have the record of proceedings of 4th of February 21, my lord. Sri so-and-so learned senior counsel assisted by so-and-so, so-and-so. Mr. A.D. Chaudhary, learned additional advocate, represent so-and-so. In the meantime, A.D. Chaudhary, learned additional advocate general shall get instruction as to what stand the government has taken on the matter recommendation made by the Director General of Police Mizoram as to increase the post of the armed branch of the Mizoram Police. My lord, thereafter, of course, the matter was not listed also on one or two occasions it was listed. But my lord, if they can, before deciding the case on merit, on an urgent basis, if this instruction is furnished, my lord.
It's not safe. Actually, my apologies that I could locate the order, last order, because there was a change of counsel. So I just got hold of this.
Letter is referring to letter of DGP.
Yes.
Lordship.
And there seems to be a rational solution.
Yes.
Yeah, Lordship, in fact, Lordship, they have annexed that annexure of page 91. So there was a decision taken on that, in fact. But of course, Lordship, that subsequently this honorable court has granted. So I can take an instruction, Lordship, about that.
What's the decision taken pursuant to this communication from the DGP?
This is on page 91, your Lordship will find.
Rejected.
Yes, it was rejected.
Any reasoning, particular reasoning?
Reasoning, there were some representations by other associations and other employees that this should not be done. So because of this was considered by, so we have filed an additional affidavit, your Lordship, stating all those facts, why it was basically rejected.
This is no the unreasoned communication.
Yes, yes, that's. But in an additional affidavit we have filed, so there we have stated about why it was rejected.
Their own police personnel, my lord, is a question of moral of the force.
No,
Why didn't the others appreciate?
The only thing is that, Lordship, the process is little bit different. The qualification, the process of recruitment, there are differences, Lordship, that is there. And Supreme Court is.
Only difference is armed branch.
Lordship, as far as like recruitment of inspectors are concerned, like what happens is that like in the unarmed branch, so if direct recruitment is there, 50% direct recruitment is with the educational qualification graduation. But in the armed branch, the only way to get into inspector is like promotion. And like that FIDA there is constable. Constable is Lordship only HSLC files. There are differences.
Give them, those who are qualified, give them.
So there are.
You can keep the qualification same.
So
You can maintain the qualification for both the
yes,
cadre.
uniform.
So those persons who are better qualified in this particular side, they will get the opportunity.
Yes.
So the balance will be maintained for qualifications, but at least they will have a chance of being promoted.
So that is true, Lordship, but the only thing is that their qualifications are not sufficient to.
When we can say, that's what you can keep the qualification benchmark same and then give them the opportunity.
It is
You
not
don't
even.
want to dilute the qualification, okay, understood. Keep the qualification same. Then give them the same entry level into the promotional channel.
So there are, Lordship, I mean, there are 2-3 stages in the unarmed branch. So recruitments are there, direct recruitment, there are a process of direct recruitment, a certain percentage of
Why
course.
already you file an affidavit
Lordship.
in regards to this? Stand is already there, Mr. Chaudhary.
Stand is
No, my lord, it's not a speaking. In spite of that, this honorable court has passed that order, my lord.
All right, you explain.
Yes.
No,
So, Lordship, kindly have a look at page 88, para 4, DGP's level. One small paragraph, my lord. Para 4 at page 88.
That is quite a considered.
Yes, page 88, my lord, para 4. And you see, the scope of promotion of armed branch inspectors are
So
limited.
we ask you to give an affidavit to give a detailed explanation as to why this recommendation has not been.
Yes.
This one-line order is rejected. Even give an
The
explanation.
Lordship, to that extent, Lordship, there was another order, and by that order only we have filed an affidavit, the additional affidavit
Which
we
is
have
the
filed. In the additional affidavit, if your Lordship can pick up their additional affidavit filed by the state of Mizoram.
Additional affidavit.
Additional affidavit. yes.
Yeah, আমার কপি দিছা? এটা নাই
Are
কিন্তু।
you having the additional affidavit, Mr. Chaudhary?
My lord, I am not finding in my file. দিছা নাই নাকি? নাই দিয়া।
Vote according,
Maybe in this
2019.
one.
It was filed in 2019.
Whole file which is there of the additional affidavits.
My lord,
Affidavit in opposition. This is in 2017, sir.
2019, Lordship, there was one. additional affidavit.
19 additional affidavit on behalf of respondent number 3.
Yes, Lordship. That's one number 3, yeah, Lordship.
Are you having
I
that,
don't
sir?
think copy was given to us.
Page 200 to 209.
No, it's not there, my lord.
Copy
Where-
दीजिए.
We are having affidavit in opposition filed by respondent number 3. We are having affidavit filed by respondents number 6 to 11 and affidavit in opposition by 1 and 2.
Lordship, it was filed in 2019, so
But if this affidavit was there, what was the occasion for us to pass this order?
29 January.
yes, 2000, like Lordship, it was in the month of
January 2019.
January, Lordship, January
On behalf,
2000.
behalf
This-
of respondent 3.
Yes, Lordship. This also detailed explanation has been given, why it was, decision was taken.
No, this is a reply affidavit.
No, this is additional.
We have this.
No, this is,
Have a look at this affidavit, sir. You'll
This
have
is
the-
a reply by us, my lord.
No, no, no.
No, page 200.
200.
Okay.
If you file a reply to this affidavit,
No, my lord, to reply to, oh, additional affidavit is there. The key is there. Is this? Copy
so para 4, Lordship, that is.
then they have to respond to this affidavit or make arguments in reference there.
Oh, my, now. I got it. They have submitted in Aizawl Bank.
Maybe.
Mr. Malhotra.
Oh.
Provide a copy of the additional affidavit dated so and so. We provided to Shri Chaudhary, Learned Senior Counsel, representing the petitioner, who prays for and is granted 2 weeks time to complete his instructions.
My lord. In the meantime, they may also have that instruction, my lord, or,
That is already there.
okay. Or we'll argue on merits, my lord, in that.
Yes,
on
already.
next day.
Let's stop it.
Also, kindly give a date, my lord, after 2 years.
This on 22nd March.
My lord.
Item number 31.
Anganwadi.
No, no. this is not. PL. Namburi. Yes.
Yeah, please, Lord. Lordship, this case, my lord, petitioner approached.
The approval has been granted. Your PIL was filed on the ground that no approval was granted. Now the approval has been granted.
Pass on this order.
Your prayer was for inquiry.
Yes,
Yes,
Lordship,
Lord.
basically that.
Uh,
So the inquiry has been initiated.
Lordship, that.
Then this PIL can be closed.
Oh, Lord.
Heard Mr.
My lord, myself, S. Rana.
S. Rana, appearing for the PIL petitioner, and Ms. M. Bhattacharjee, appearing for additional senior government advocate, appearing for the state of Assam. Mr. Goswami for?
Section number 8, Lordship, table going to.
This inquiry was initiated in March 22.
Yes, Lord.
What has happened thereafter?
Lordship, that update I don't have right now. Lord.
We'll direct that this should be
Yes.
concluded.
Yes,
earliest.
Lordship. Lordship.
The PIL was directed seeking seeking a direction from this court to institute an inquiry into the alleged misappropriation and misutilization of funds allotted to the Dibrugarh University. Dibrugarh University, Assam Agricultural University, Jorhat, and Tezpur University. Full stop.
Guwahati University also is there.
As well as Guwahati University, full stop. During the pendency of this PIL, it was submitted on behalf of the government that due approval from the competent authority was sought for proceeding with the inquiry in terms of complaint received by the Vigilance Department, full stop. Mrs. Bhattacharjee, learned additional senior government advocate, has submitted that on 9/3/2022, the permission has been granted to initiate, approval has been granted to initiate a preliminary inquiry against the then Chancellor of the Agricultural University, Jorhat, and others. Also, accordingly, councils are in agreement that the prayers made in the PIL has been initiated. In terms of the prayers made in the PIL, inquiry has been initiated. Full stop. Accordingly, the PIL petitioner submits that in view of the communication dated 9/3/2022, according approval by the competent authority to initiate preliminary inquiry, nothing survives in the PIL and therefore PIL may be closed. Upon submissions of the learned counsels for the appearing for the parties, and in view of the order dated 9/3/2022, since approval has been granted to initiate a preliminary inquiry, we find that the prayers made in the PIL petition has been accorded to, and accordingly nothing further survives to be decided in this PIL. The PIL is therefore closed and disposed of. However, it is made clear that the respondent government will take all steps necessary to ensure that the preliminary inquiry is carried out in right earnest and completed completed as expeditiously as possible within is concluded. The inquiry should be concluded and taken to its logical conclusions as early as possible, at the earliest. PIL, accordingly, in terms of the above, stands closed and disposed of.
But may I have a